only that AIDC matter, item number 4, it's partnered. But their counsel has some difficulty, AIDC, they have informed me last night. So they are seeking for an accommodation. But my problem is that I have to do it after 15th of August only.
We release it from partner. We'll see. It has been submitted by the counsel appearing on behalf of the AIDC that he has some difficulty. Taking into account that the matter has been partnered, released from partner to be listed again. The registry shall list the matter. When?
After 15th of August, any day.
On 28th of August, before the approval.
Yeah, bless.
When the vetting, I am likely to receive the FAD by tomorrow. My lord, I will file my FAD by the after tomorrow. My lord, this matter will any day next week.
What is the matter about?
This is my lord, the order passed by the state level. I'm appealing for that.
Mr. Ardhar appearing on behalf of the
affidavit, my lord, I am not seeking a long adjournment. Just, my lord, next week any demand.
is a state.
And my lord, we are private respondent and petitioner.
Who are you?
On the basis of their complaint, my lord.
How?
Okay, please, my lord. But my certificate has been cancelled by the scrutiny committee on the basis of a complaint caused by the private respondent. Now I have challenged the order of the scrutiny committee. Now the department has to say whether it.
Who are you?
And only
Mr. Ardhar, the learned counsel appearing on behalf of Plain Tribes Department, Tribal Affairs Department of the Government of Assam submits that the affidavit would be filed within a day or so. List the matter again on 13th of August 2024. Full stop. In the meantime, the affidavit be filed by the Plain Tribe Department shall file the affidavit without fail by 26th of July 2024. The petitioner as well as the private respondent would be at liberty to file their reply.
I beg to mention one item, my lord. It was last listed on, my lord, 15th of March, my lord. My lord, there's an order to list this matter after 2 weeks, my lord. Since then, it's not been listed. So I pray, my lord, maybe was it for my lord, that's my lord. On 31st of
Fixed it for hearing.
my lord, ordered, my lord.
It will be on 31st of June.
Please, your lordship, I beg to mention for listing. Have a come up hearing on next week, Tuesday, my lord.
Absolutely no.
Or any
Go
other
before
day.
the registry. Nothing doing.
Yes, it's long, the matter was several times.
It's a hearing matter. Hearing matter, you don't mention it.
Public.
For one.
So, Mr. Deka, what do you say about that aspect?
Regarding my lord, judgment passed by the trial court member and the pet court member. One part is correct, my lord. It is authenticated. And it is probate was granted in respect of land, my lord. Regarding my lord, house, my lord, he cannot decide.
No,
it.
that is okay. Then I am not on that. What will happen to the probate in view of the death of the person?
Death of the person, my lord, her part will go to as usual course, my lord. They are-
So are you saying that one appellant will be only entitled to half of it?
Yes,
The
ma'am. As
probate
per-
has to be limited only to half of it.
but that is the intention of the will, my lord. May I read, my lord? Will is, my lord. May I read, my lord?
Yes. Where is the will? The will consult. Exhibited documents.
Yes, my lord. Then
The documents খিনি ক'ত আছে? I will. Yes, got it. Tell me.
my lord, I see Ramakanta Sharma so and so, resident of so and so, being desirous to making provisions of my house and landed property, do hereby revoke all my former will and codicil made by me, and hereby make and declare this as my last will and testament, whereby I bequeath and devise to my two daughters, Srimati Aditi Sharma, who is presently unmarried and is in my care and custody, and Srimati Dipti Thakur, wife of so and so, a resident of so and so. That's very absolutely in equal proportionate uh, proportional all the some type residential house which consists of 17 room besides bathroom, sanitary latrine, kitchen and veranda constructed by me 15/20 years ago and which is under my occupation along with the second class Basti land upon which the said above mentioned house is standing at Digambar Shop, Joint Town Moja, more fully described in the schedule below, with all existing privilege, settles and tenement the thereon, and which I may possess or entitled to act in the time of my death. The said house and the vacant land on the front and rear side of the house shall be divided between my said two daughters in equal proportion according to their convenience. And I hereby appoint them, the said Srimati Sharma and Srimati Dipti Thakur, the sole executor of my this will. This is the will, madam. So their property was given to both their daughters.
Now, Mr. Dekar, what is the role of a probate court? I am sitting in appeal.
Yes,
So
whether my
the
lord,
role is only to
indication
see
of-
the veracity of the will
yes, my lord.
as to whether the will has been done in a proper manner. That's all.
Yes, my lord.
Thereafter, what happens is the subject matter of a suit.
Yes, my lord.
Isn't it?
Therefore, my lord, probate was granted, my lord. To
The
take of-
probate has to be granted as it is.
It is, my lord. It should be as it is, my lord.
It be
Cannot be
granted as
different.
it is. Nothing to do with anything as
Yes,
to
my lord.
whose land it is or whose heir.
Yes, my lord.
If there is anything else which has happened out there, that is a subject matter of
Yes,
suit.
my lord. Even if there are.
As to whether your father had the authority or has
Yes.
the right over the land is a different aspect to the
Yes.
matter. The only
if
thing to
there
be
is no
looked
authority,
into
then
is
title
as
will
to
decide,
whether the will
Yes.
has been executed, and it is just whether the probate court has put the stamp of authority accordingly.
Yes, my lord. But during the stamping and authority, my lord, but he have go beyond his.
So that I understand. There's no quarrel with that. Yes, would you have to say anything more? No, the question as to whether you have a right over the house is a subject matter of a suit. When they claim or anything happens, which has nothing to do with here. As regards the land also, it is a subject matter. Only thing which this court has to look into it as to whether the learned first appellate court was, trial court was justified in granting the issue involved is very limited as regards the mistake committed by entering into the title. And your cross-objection has no value. You should have filed an appeal against that if you had. But your suspicious condition does not exist because of you see your affidavit, and the examination of you yourself said that he was only suffering from kidney ailment. It has nothing to do. Well, let me dictate it. Mr. এইকেইটা একেলগে দিব হা টেষ্ট এপিল নাম্বাৰ 2/2007 আৰু সেই ক্ৰছ অবজেকশ্যন আই এখন আছে ক্ৰছ অবজেকশ্যন This case number 1782/2012. First level, huh? Heard Miss S. Sharma, the learned counsel appearing on behalf of the applicant, and Mr. Yes, Deka, assisted by Miss P. A. Vachaji, appearing on behalf of the rest. Opposite party number 2. This is an application filed seeking the leave of this court to file the accompanying cross-objection against the judgment, against the judgment and order dated 16/12/2006, passed in title suit bracket probate number 30/2001 by the learned district judge Jorhat. Goes to CPC consult. For deciding the said application, this court finds it relevant to take note of Order 41, Rule 22. Which stipulates that a cross-objection can be filed within 1 month from the date of service on the on the applicant or her pleader of the notice of the day fixed for hearing of the appeal, or which such further time as the appellate court may fit to allow. It has been stated in the instant application that the applicant, after receiving notice from this court, had engaged an advocate to represent her in the appeal. And the advocate, after going through the records, found that the appeal was admitted by this court on 11/4/2007 and suggested to file cross-objection. There is no mention as to from when the applicant received the copy of the had received the notice of the appeal. In the application, there is no mention as to when the advocate suggested filing of the cross-objection. It is also seen that in the year 2011 itself, the applicant came over for filing of the cross-objection. However, the cross-objection was filed only in the year 2012. There is no explanation as to why the said cross-objection could not be filed within time. Under such circumstances, this court is not inclined to grant the leave for filing of the cross-objection. Accordingly, the instant application being being devoid of any merit stands dismissed. Cross-objection 1 Cross-objection 1/2012. This court, by an order dated in Miss Case number 1782/2012, refused to grant the leave to the applicant to file the cross-objection in view of the delay. Under such circumstances, the instant cross-objection cannot be entertained, for which the same stands dismissed. I mean, test appeal number 2/2007. Test case. Appeal. Test case. Okay. The instant appeal is filed under Section 299 of the Indian Succession Act 1925, challenging the judgment dated 16/12/2006 passed in title suit Probate number 30/2001 by the learned district judge Jorhat, At the outset, it is relevant to take note of that the instant appeal was filed by two appellants. However, one appellant expired, and accordingly her name was struck off by an order passed by this court on 24/8/2017. The brief facts leading to the filing of the instant appeal are that one Ramakanto Sharma, Prabha Pandit, during his lifetime, executed a will which was duly registered on 15/9/1990. 1990 or 1980?
1990.
1990. In terms with the said will, the said late Ramakanta Sharma Pandit, Sharma Sabha Pandit, for short, hereinafter referred as the testator, had bequeathed a Assam type house bearing municipal holding number 193 in ward number 1 of Jorhat Municipal Board, Jorhat, consisting of 17 rooms, besides bathroom, sanitary latrines, kitchen and verandas, along with the plot of land measuring 1 katha 19 by 1/4 lecha, covered by dag number, periodic patta number, and covered by dag number 1225 old 1391/2160 new, included in PP number 204 old 298 new of block number 6 of Jorhat Town Moda within the district of Jorhat, with specific boundaries, in favor of his two daughters, the appellants herein, who are the appellants herein. It is relevant to take note of the state will was attested by two witnesses, one Sri Harendra Nath Sharma and the other Sri Tapan Thakur. The testator expired on 13/9/1995 at the age of 84. Pursuant thereto, a probate proceedings was initiated, being probate case number 29/2000. Taking grant of probate in favor of the applicants who are the appellants herein. In the said probate proceedings, the respondent herein were made parties. At this stage, it is relevant to take note of that the respondents herein are the daughter, are the wife and the daughter of one Noni Kumar Chakraborty (brackets) since deceased, who is the brother of the appellants herein. The respondents, upon appearing, objected to the grant of probate by filing written objection. By raising issues that the said will was executed under suspicious circumstances. And the house, which was a part of some type of house, which was a part of the property bequeathed in favor of the appellants, was constructed by late Noni Kumar Chakraborty during his lifetime. On the basis of the said objections so made, the said probate proceedings was converted into a suit which was registered and numbered as title suit probate number 30 of 2001. At this stage, it is very relevant to take note of that a perusal of the probate proceeding, probate application, World probate application form. Reveals that the said probate application was supported by the two attesting witnesses, namely Sri Harendranath Sharma and Sri Topon Bhattakur, who were present when the will in question was executed by the testator. On the basis of the objections so filed, four issues were framed in the form of points of determination, which were: number one, whether the will bracket exhibit A was duly executed by the testator said Ramakanta Sharma Sabhabandit in his good health and mental condition without any influence or duress under the petitioners. Question mark. Number two, whether the house standing on the land as included in the will in question and described under the schedule of the probate petition belonged to the said Nani Chakraborty, being the husband of the opposite party number one and the father of the opposite party number two, which the opposite party number one owns after the death of her husband and after the death of the said testator, being the father of the deceased Nani Chakraborty. Number three, whether the two lessees of the land included in the said will were acquired by the government per the order dated 9/7/1970 in the land acquisition case number 109/08/69, question mark. Number four, whether the petitioners are entitled to the grant of the probate of the said will, question mark. On behalf of the appellants who were the applicants to the said probate application, four witnesses were examined, including the applicants. And 5 witnesses were examined, including the applicants. The 2 attesting witnesses and 1 LD assistant of the Jorhat Sub-Registry Office had submitted their evidence and were cross-examined in addition to the applicants. On behalf of the respondent, there were 3 witnesses, including the opposite party number 1, respondent number 1. It is, however, relevant to take note of that amongst the 3 witnesses, 1 witness did not turn up for the cross-examination, who was Srimati Soru Bhattakur, and as such, her evidence was expunged. The learned District Judge, Jorhat, by the judgment dated 16/12/2006, disposed of the said proceedings. The point of determination number 1 was decided in favor of the appellants. Thereby holding that the will was executed voluntarily in good health and mental condition and without any influence or duress from the applicants. In respect to the issue number 3, point of determination number 3, it was held that the said point of determination could not be held in the decided in the affirmative on account of want of documentary proof. In other words, the point of determination as to whether the 2 lessors of land included in the will were acquired by the government as per the order dated 9/7/1970 in land acquisition case number 109/08/69 could not be proved. The contesting point for determination was the point number 2. The learned district judge, while deciding the point number 2, decided the question of title as regards the house standing over the land in question. Or for that matter, decided as to whether the testator had the competence to bequeath the Assam time house in favor of the appellants. In view of the decision recorded in respect to point number 2, the point number 4 was decided in favor of the appellants, thereby granting probate only in respect to the land and not the house. It is in respect to the next being aggrieved by the determination so made by the learned district judge in its impugned judgment dated 16/12/2006 in respect to the point number 2, the instant appeal has been filed. by the appellants before this court. In the backdrop of the above, the issue which arises, the point for determination which arises for consideration is as to whether, next paragraph, as to whether the learned district judge was justified in deciding the question of title in respect to the Assam type house which was bequeathed by the registered will dated 15/9/1990 by the testator in favor of the appellants. I've heard Mr. P.S. Dekar, the learned counsel, senior counsel, appearing on behalf of the appellants, who submitted that the will, that the probate court would not have gone into the question of title. The learned senior counsel further submitted that the duty of the probate court is limited to saying as to whether the will was executed in accordance with law and as to whether the will was executed under suspicious circumstances. The learned senior counsel submitted that the question as to whether the Assam type house belonged to the testator and as to whether the testator had the jurisdiction and authority to bequeath the Assam type house in favor of the appellants is a question to be decided by the civil court, if need be, and not by the probate proceed, not in a probate proceedings. Anything else? No? On the other hand, Ms. S. Sharma, the learned counsel, appearing on behalf of the respondent, submits that the house which was bequeathed by the will dated 15/9, registered will dated 15/9, purported registered will dated 15/9/1990, could not have been bequeathed by the testator, taking into account that the house was constructed by her husband, by the predecessor of the appellants, of the respondents, late Noni Kumar Chakravarti, during his lifetime. He further submitted that the respondents are presently in possession of the house in question. And as such, the learned district judge was justified in not granting the probate in respect to the house in question. She further submitted that the will in question was executed under suspicious circumstances. Inasmuch as the testator, who was residing at a stone throw distance from the registered office, did not go to the registered office, and the will was executed by way of a commission. He submitted that it was under undue influence. The will was executed. Madam, I don't think we should put the attesting witness did not say. It would show on a very poor light, because everything is shown. the attesting witness. This court have duly heard the learned counsels appearing on behalf of the parties and perused the materials on record, including the evidence. A perusal of the will, which had been registered on 15/9/1990, shows that the Assam type house as well as the land mentioned in the schedule to the will have been bequeathed in favor of the appellants. The will was executed in presence of two witnesses, one Sri Horendra Nath Sharma and the other Sri Tapan Bhattakur. When the application seeking probate was filed on 20th of May, on 8th of February 2020, the said application was duly supported by the two attesting witnesses, supported by the verification made by the two attesting witnesses. Subsequent thereto, when the application was amended in view of the objections so filed by the respondents, by filing an application on 20th of May 2003, the said application was also attested by two, verified by the two attesting witnesses. This court have also duly taken note of the evidence of the evidence, the evidence, the evidence of the witnesses, and more particularly the evidence so tendered by the attesting witnesses, both the attesting witnesses. Nothing would be taken out during the cross-examination of the said attesting witnesses, or for the matter, the applicants, public the appellants, to show that the said witnesses, as to show that the will, the registered will dated 15/9/1990 was executed under suspicious circumstances. Therefore, the submission made by Ms. S. Sharma to the effect that the witnesses, the will, registered will dated 15/9/1990 was under suspicious circumstances, does not hold water. The most important point for determination in the instant appeal is as to whether the learned district judge was justified in learned probate court was justified in entering into the question of title as regards the property which have been bequeathed. It is no longer res intriga that the probate court only certifies the correctness, certifies the execution of the will by the testator. In accordance with law. The question that probate court is not required to enter into the competing claim of the parties as regards the title of the land or of the properties bequeathed. It shall be within the jurisdiction of the civil court to decide if a question due arises as regards the right, title, and interest over the properties in question. Under such circumstances, it is the opinion of this court that the learned probate court was not justified in deciding the point number 2, thereby point number 2 and point number 4. Thereby holding that the appellants herein would be only entitled to the land and not the house. The learned probate court have been already, learned district judge, having already come to an opinion that while deciding the point number 1, that the will in question, registered will dated 15/9/1990 was executed without any undue influence and in accordance with law, ought not to have entered into the controversy as to whether the house was constructed by the as to whether the house belonged to the testator or to his son, like a predecessor in interest of the respondents. Accordingly, this court therefore interferes with the decision of the learned district judge in the impugned judgment dated 16/12/2006, insofar as point number 2 and point number 4, and holds that the appellants herein would be entitled to, appellant herein, the probate of the will in so far as regards the property so bequeathed therein. Accordingly, The instant appeal therefore stands disposed of with the interference as regards the point number 2 and point number 4 to the impugned judgment dated 16/12/2006 entitled suit probate number 30/2001 to the extent that the appellant number 1 herein would be entitled to the probate of the will of the registered will dated 15/9/1990, which includes the property so bequeathed therein. This court also further finds it very pertinent that it states to clarify that this court has not decided as regards the title of the property so bequeathed by the registered will dated 15/9/1990. Any of the parties having any issue as regards the right title and interest over the property so bequeathed shall be at liberty to approach the appropriate court wherein such questions can be decided. The registry shall make a decree. Accordingly, the registry is directed to make a decree. No, the registry, no. No. This court directs the registry to forthwith return the LCR back to the court below, to the court of the learned district judge, Jorhat. And the office of the learned district judge, Jorhat, and the learned district judge, Jorhat, shall issue necessary certificate as regards the grant of probate in accordance with the provisions of the Indian Succession Act 1925.
Second appeal, my lord. My lord, this second appeal has been preferred against the judgment and decree dated, my lord, 29/5/2008, passed by the learned civil judge Hailakandi, my lord, in dismissing the side appeal, my lord. My lord, what happened, my lord, in the original suit, I was the plaintiff, my lord, plaintiff appellant, my lord. My suit was dismissed, my lord. Appeal dismissed, my lord. Against that appeal, my lord, I have preferred this second appeal, my lord. And in the, my lord,
You are the plaintiff?
plaintiff appellant,
Plaintiff.
my lord.
What is your suit for? Where is the plaintiff?
Put for plaintiff, my lord, RSA 53 plaintiff.
Where is the plaintiff?
24, my lord, at page 24
Of which appeal?
of RSA 53 of 2009. Put for right title interest and recovery of possession, my lord.
You are the plaintiff.
Well.
Radha Raman Das.
Radharaman Das.
Suit is for declaration of right title. That the suit in Lal Chandra sir. Yeah, kindly come to page 25. Para 6. Read.
That on 11/4/2024, the defendant along with other some miscreant, including his son, attempted to take forcible possession of the dwelling house by threat and coercion. The matter was reported to the officer in charge of Pasgram Police Station outpost, but the in charge, without accepting that FIR, registered a false case against me and others, and an FIR filed by the defendant and arrested all male members of the family and keeping them in lockup. All female members and children are driven out of the house and kept the safe and the lock and key.
So on 11/4/2004, your possession was taken
It was disposed by.
from the land. Okay, this is your suit. Then what is the stand of the defendants?
But the written statement is at page 28.
You purchased the suit land on
I purchased the suit on 3/3/2004, man.
2004
Not
from Krishna Orang.
from Krishna.
And who is the defendant?
Defendant is Malad Mahadev Purang.
And what is your name? Radharaman.
My name is Radha.
Let's see the judgment of the trial court.
Trial code is at page 10. Eleven,
Trial court judgment is where?
page 11, my lord.
11.
Lordship.
Is there any cause of action, whether the plaintiff has right title, whether the deed was so and so, truth is the plaintiff has purchased the given so and so. So, claim and counterclaim both dismissed,
Both dismissed, my lord.
then appeal filed.
Then what against the suit?
And you did not produce the originals of your deed of purchase.
Certified copy. But
Did you take the permission out there? It was put under objection. Let us see the appeal.
My lord,
There are two appeals.
judgment, two appeals made against this appeal, against the suit and against the counterclaim. Is five, my lord. Appellate court judgment is surmises conjecture, my lord, without determining point for determination. My lord. One, two, three.
There is another suit.
Another appellate court has, my lord, held that it is barred by res judicata, my lord.
Huh?
Barred by res judicata. Another suit, my lord, that is, my lord, exhibit go. If your lordship peruse, then it is completely separate, my. I was not here, my lord, involved. Exhibit go in the case. Title suit 62 of 1992, my.
So the appeal was dismissed.
It was dismissed,
And why, and the appeal filed against the counterclaim was
allowed.
allowed. Let us see that. What was the counterclaim for?
It's 4 minus, please. At page 34, minus. That meaning there, the owners of the land by inheritance.
Well, read it. Now let us see the points for determining substantial questions of law formulated. Judgment passed by the landlord dismissing the suit filed by the appellant for recovery over the suit pending holding that is sealed in Swansea by. How does the first substantial question of law arise? It's a secondary piece of evidence. How can you bring secondary evidence without 65 complying with 65? Whether the impugned judgment and decree part and in the suit. How are other aspects relevant? Whether the impugned judgment and they are holding that the suit filed by the plaintiff is barred by res judicata and decreeing the counterclaim filed by the AR without taking into consideration, and particularly the case possession. You should know, your basic case arises out of those two sale deeds.
Okay.
And you have given certified copies. Matter ends there. And what is the counterclaim for? That is why not being able to find out what is the counterclaim.
Counterclaim, my lord. Is, my lord, RSA 54 of 2009, it at
Page,
page
where is the counterclaim?
34, my lord. Page 34.
Page 30,
34.
34 is the counterclaim.
Question. RS 54 of 2009. There was a complaint.
Against the counterclaim, what is the counter decreeing so and so. Let me come back in 5 minutes. Where is the judgment? Okay, yeah.
Judgment. I,
54 is the against the counterclaim. His suit was filed was number 24.
24 months, 24 of 2006.
Yes, what case?
My lord, I will draw your kind attention, my lord. Exhibit Go, my lord.
Huh?
Exhibit Go, my lord.
Huh.
Exhibit Go by which the learned appellate court, my lord, held that the entire court is barred by res judicata, my lord.
Ah,
But, if I go to the exhibit Go, my lord, then you find that the similar parties are not similar, my lord, and land in question are also different.
land in position is the same.
It's
There
different.
is a finding of fact.
80, 81, and 82, my lord, my dag. And so far their dag is concerned 80, my lord.
80 and 81. If it go, you see, topsil ko.
But it is in vernacular.
প্রথম নম্বর তফসিল জেলা
সরসপুর জেলা কাছাড় পরগনা সরসপুর মৌজে 5 গ্রাম স্থিত দ্বিতীয় রিজরিপা 162 নম্বর পাটার 80 দাগ অংশ ও 81 দাগের সামিলে মোট 1 বিঘা 300 টাকা।
your land is 3 katha 11 shatak,
11
which the learned first appellate court holds it to be a part of this dag.
দাগ নম্বর 82 is quite different, my lord. 8 shatak, my lord. Small portion of land, 8 shatak, my lord. That has not been decided, my lord. The core issue, my lord, is disposition, my lord, in this. That has also not been framed by the learned trial court as well as the appellate court.
Not possession, but you had to prove your title. For proving your title, you did not bring into those documents. And these were put under objection.
But subsequently, my lord, I have collected the original copy, my lord, from the sub-registry office.
Hmm?
Exhibit 4 and exhibit 5, my lord. I have collected the original copy from the certified, from the sub-registry office, my lord. Later on, my lord.
Where? There is no exhibits.
But exhibit 4, exhibit 5 is a certified copy of said deed. It is right, so.
Exhibit 1 is the Khotian.
Exhibit 1 and 2 are the Kotians, my lord.
Exhibit 4 is the purchase deed.
The purchase deed of my.
Exhibit 5 is a Xerox copy of a lease deed. Xerox copy, challan showing payment of government revenue. That's it. Tomabandi is what? No other document.
My lord, my lord, RSA 53, my lord, against the suit, my lord. The whole issue, my lord, must be decided, my lord. That has been not decided by the learned appellate court below in a surmise and conjecture manner, my lord, was the imperial order. So if your lordship, after going through the records, my lord, after perusal of the materials available in record, my lord, feels that, my lord, the substantial question of law is not formulated, my lord, in accordance with the law. Your lordship can reformulate it, my lord.
I can formulate, but the thing is there is nothing to formulate. That is the problem which is arising, Mr. Counsel. This is how the issue number, how they have taken issue number 3.
My lord, the appellant, my lord, subsequently, my lord, collected the copy, my lord, original copy.
Now, who is this Pradeep Singh? Pradeep Singh.
Pradeep Singh Sheep. Pradeep Singh Sheep, he is another person, my lord, he is not connected.
Huh?
Pradeep Singh, my lord,
Who is the Pradeep Singh?
Pradeep Singh, my lord, is Pradeep Kumar Sheep, my lord. Pradeep Kumar Sheep, son of late Avanti Kumar Sheep. He was the defendant, my lord, in earlier title suit number 62 of 1992.
You purchased from?
Actually, Krishna Urang, my lord.
And how is Krishnaram connected with Rabiram?
My lord, Krishna Urang, my lord, first, my lord, Shukuram Urang, who was a tenant under Sardar Chandra Singh, my lord. And from Chandra Singh, Mukti Singh is there. Mukti Singh is the descendant
Huh?
of Chandra Singh, my lord. Mukti Singh, my lord, is the descendant of Chandra Singh. From Mukti Singh, my lord, Krishna Urang purchased the suit land, my lord. And I have purchased from the Krishna Urang, my lord. I have stepped in the shoes of Krishna Urang, my vendor.
Yes. Defendant number 4 is Krishna Urang in that matter. in that suit, title suit 4262 of 1992.
My lord, yes, Vishnu. But issue, my lord, suit is different.
Huh?
Issue, my lord, suit is different, my lord.
But the land is there. Whether it has been given in favor of the plaintiff, who is the appellant here.
Land is different, my lord, and their boundary schedule is also different, my lord.
The boundary, the first appellate court holds that it is the same land. The question of law, it's a question of fact. Hello, let me.
Lord, if
I tried my best to find out something as regards the counterclaim. But this seems to be
for the proper adjudication of the matter, if your lordship please to remand back the matter, then my lord,
not demanding, it's too old the matter. There has to be some settlement.
why to prove the original of the document, my lord. So earlier occasion, my lord, the court below, my lord, the counsel for the plaintiff did not show, should not file to the record.
Heard Mr. Teulowska, the learned counsel appellant appearing on behalf of the appellants in both the appeals. This court had earlier heard Mr. S. Bhattacharjee appearing on behalf of the respondent in the instant appeal. It is seen that this court, by an order dated 3/6/2009, admitted the both the appeals. Admitted RSA number 53/2009 by formulating three substantial questions of law, which reads as under. In RSA number 54/2009, there is no separate questions of law formulated. However, while hearing the matter on 26/2024, this court had observed that the substantial questions of law which have been formulated in RSA number 53/2009 would cover the RSA number 54/2009. For deciding both the appeals which are interconnected, this court finds it relevant to take note of the brief facts which led to the filing of both the appeals before this court. The appellant in the instant appeal as plaintiff had instituted a suit being title suit number 24/2006. The appellants in both the appeals as plaintiff had instituted a suit being title suit number 24/2006. The facts leading to the filing of the said suit were that one Sukram Urang was a tenant under one L. Chandra Singh. Under late, I think it should be late. Late was a tenant under L. Chandra Singh. It was averred that there was a Khatian number 52 issued as a proof of his permanent non-evictable tenant. Thereupon, after the death of the said Sukram Urang, one Krishna Urang stepped into his shoes and was in peaceful possession by constructing houses. The said Krishna Urang thereupon purchased the right over the suit land from one Mukti Singh, who was a descendant of late Chandra Singh, Sinha, S-I-N-G-H-A, Sinha, on 3/3/2004 by a registered deed number 515/533 and became the owner of the suit land. On the same date, another sale deed was executed by the said Krishna Urang, bearing deed number 518/536, dated 3/3, thereby transferring the right over the suit land in favor of the plaintiff. It was averred in the plaint that the defendant used to reside in the northern boundary of the suit land, which was intervened by a passage to the house of the plaintiff. On 11/4/2004, the defendant, along with others, trespassed into the said suit land and dispossessed the plaintiff. It is under such circumstances the suit was filed, seeking declaration of right, title, and interest of the plaintiff over the suit land, for recovery of khas possession by breaking the lock and by evicting the defendant or any unauthorized persons who may be found in illegal occupation of the suit land. Pursuant to the filing of the said suit, the defendant appeared and filed a written statement stating inter alia that the suit filed by the plaintiff is a false suit, false and a frivolous suit, inasmuch as the plaintiff or his predecessor in interest did not have any right over the suit land. It was stated that the plaintiff and one Rabia Urang had purchased a plot of land measuring 1 bigha 4 katha 4 chataks from one Niranjan Singh by the registered deed number 7048 dated 2/12/1978 and got possession thereof. Thereupon, one Pradeep Kumar C purchased land measuring 15 kathas of the said patta by the registered sale deed number 229 dated 8/2/1989 from one Fulia Urang and Malati Urang, but did not get possession as the said land was already transferred to the plaintiff by his brother Robia Urang in favor of Robia Urang for maintaining his brother's wife and daughters. Under such circumstances, the plaintiff the defendant had filed a suit being title suit number 19 of 1989 and title suit number 62 of 1982, which was decreed in favor of the plaintiff. And the vendor of the plaintiff was a party to the said suit. It was also mentioned that once Sama Urang and Sukram Urang had a Kacha Khatian number 52 under Sardar Chand Singh for land measuring 8 katha 10 chataks, the ownership of which was purchased by the plaintiff and his brother by the registered sale deed number 7048 dated 2/12/1978 and became the absolute owner wherein they were in possession prior to the purchase. It was mentioned that the Kacha Khatian was never became Pakka, and as such Sukram, the father of Krishna Urang, did not get any heritable right, and the same was purchased by Rabia and Mohadev, Rabia and the plaintiff, and the defendant. It is under such circumstances the defendant also filed a counterclaim for declaration that the sale deed dated bearing deed number 518 dated 3/3/2004 and sale deed number 536 dated 3/3/2004, on the basis of which the plaintiff claimed its right, title, and interest over the suit land, was void, illegal, inoperative, collusive, sham, and did not confer any title, right, title, or interest to the plaintiff. And also for a declaration that the said documents be liable to be cancelled. To the said counterclaim, which was filed by the defendant, the plaintiff also filed the written statement. On the basis of the pleadings, the learned trial court formulated framed 4 issues. Issue number 2 pertained to as to whether the plaintiff had right title over the suit land. And issue number 3 pertained to as to whether the deed number 518 and 536, both dated 3/3/2004, to which the plaintiff had purchased the suit land from one Krishna Urang, is void, collusive, and liable to be cancelled as prayed for by the defendant / counterclaimant. On behalf of the plaintiff, 2 witnesses were examined and 8 documents were submitted. And on behalf of the defendant, 3 witnesses were examined and 8 documents were submitted. It is relevant to take note of that the plaintiff exhibited only the certified copy of the deed numbers 518 and 536, both dated 3/3/2004 as Exhibit 4 and Exhibit 5, which were put under objection. On behalf of the defendant, it is relevant to take note of that the deed of sale bearing deed number deed of sale bearing deed number 7048 dated 7/2/12/1978 was exhibited as Exhibit Core, and the judgment so pronounced in title suit number 62/92 was exhibited as Exhibit Go. amongst the other documents. The learned trial court, by the judgment and decree dated 25/6/2007, dismissed both the suit as well as the counterclaim. The suit was dismissed on the ground that the plaintiff failed to prove its right, title, and interest by producing the necessary documents, by producing the original documents which have been marked as, by failing to produce dismissed the suit on the ground that the plaintiff failed to produce the originals, the primary documents, that is, of the sale deeds numbers 518 and 536, are both dated 3/3/2004. And secondary evidence was produced by way of Exhibit 4 and 5, that too without taking the leave in terms with Section 63 and 65 of the Indian Evidence Act 1872. The counterclaim of the defendant was dismissed on the ground that the defendant also failed to prove that the defendant had acquired any right over the suit land and had also disregarded Exhibit Core, which was the certified copy of the deed of sale bearing deed number 7048, dated 2/12/1978. Being aggrieved, 2 appeals were filed. One appeal was filed by the plaintiff, which was registered and numbered as title appeal number 19/07, which was filed by the plaintiff, and the defendant had filed the appeal, which was registered and numbered as title appeal number 20/07. The learned First Appellate Court, by 2 separate judgments in both the appeals, passed 2 separate judgments in both the appeals. Passed 2 separate judgments on 29th of May 2008 in both the appeals. While title appeal number 19/07 filed by the plaintiff was dismissed, the title appeal number 20/07 filed by the defendant was decreed, thereby decreeing the counterclaim. It is against that. It is against the decision in both the appeals. The 2 second appeals have been filed, being RSA number, 2 second appeals have been filed, which are presently been taken up for adjudication. In the above perspective, let this court take note of take into consideration as to whether the substantial questions of law which have been formulated by this court by the order dated 3/6/2009 arises, or for that matter are involved in the appeals in question. I've heard Mr. T. Ulosco, the learned counsel, appearing on behalf of the appellant in both the appeals, who submitted that the substantial questions of law which have been formulated are duly involved in the instant appeal. He submitted that Exhibit 4 and 5 were those certified copies could have been taken into consideration by the learned trial court and not by the trial court as well as the first appellate court, and not taking the said exhibits 4 and 5 have rendered the judgments passed by the learned trial court as well as the first appellate court perverse. He further submitted, drawing their reference to exhibit 4, exhibit Go, and submitted that he further submitted, drawing reference to exhibit Go, that the principles of res judicata could not have been applied in the facts of the case, taking into account that the suit land was in respect of dark numbers 81, 82, and 83. 80, 81, and 82. Whereas the judgment which was being passed by the learned first appellate court, judgment which was passed in title suit number 16/1992 was in respect of dark number 80 and 81. And as such, there is a perversity in applying the principles of res judicata, for which the third substantial question of law which have been formulated is duly involved in the instant appeal. This court have duly heard the learned counsel appearing on behalf of the parties, as well as also peruse the materials on record, including the evidence on record evidence. Let this court first take up as to whether the first substantial question of law is involved in the instant appeal. The first substantial question of law relates to as to whether the learned court below were justified in dismissing the suit filed by the plaintiff for recovery of his possession on the basis of the previous possession over the suit land, in holding that the sale deed, that is exhibit 4 and 5, by which the plaintiff purchased and got possession over the suit land, are secondary evidence, and as such not admissible in evidence, are perverse and unsustainable in law. This court have duly taken note of the plaint, wherein the plaintiff claims that he has entered into possession over the suit land on the basis of a deed of purchase being made on 3/3/2004. There's no deeds of sale. The primary documents were not brought on record. The records also do not show that any steps were taken in terms with Section 65 of the Indian Evidence Act to bring on record to adduce secondary evidence. Under such circumstances, this court does not find any error committed by both the courts below as regards not taking into consideration exhibit 4 and 5, taking it as the same where secondary evidence, that too without following the due process. Under such circumstances, the first substantial question of law so formulated in the opinion of this court is not involved in the instant appeal. The second substantial question of law relates to as to whether the learned court below were justified in holding that the payment of rent is required to be made to the landlord even after khatiyan was issued to the vendor of the plaintiff under the Assam Temporarily Settled Areas Tenancy Act. The said substantial question of law, so formulated with due respect, cannot be said to be a substantial question of law involved in the instant appeal, taking into account that a decision in respect to the said question of law so formulated would in no manner affect the adjudication of the instant dispute. In the instant case that the plaintiff has claimed its right on the basis of a deed of sale, which, however, was not brought on record in accordance with law. The defendant, on the other hand, claimed its right over the suit land on the basis of another deed of sale, which was executed much prior to the plaintiff's purchase. The defendant further claimed its right on the basis of a deed of sale, on the basis of a judgment being passed by the Court of Competent Jurisdiction in title suit number 16 of 1992. The non-payment of the rent, as such, in the opinion of this court, had nothing to do, inasmuch as the plaintiff did not claim any right over the suit land on the basis of a khatiyan, but rather claimed its right on the basis of a deed of purchase. Under such circumstances, the said substantial question of law, so formulated, not only is not involved in the instant appeal, but cannot be regarded as a substantial question of law at all. The third substantial question of law relates to as to whether the learned First Appellate Court were justified in holding that the suit filed by the plaintiff was barred by res judicata and thereby decreeing the counterclaim filed by the defendant without taking into consideration the respective issues in both the suits, and particularly the issue of recovery of possession of the suit land by the plaintiff on the basis of his previous possession over the suit land. This court have duly taken note of the judgment and decree dated passed in title suit number 16 of 1992. In the said judgment and decree, the vendor of the plaintiff was arrayed as the defendant number 4. 62 of that. Was arrayed as the defendant number 4 in the said suit. And in respect thereto, the plaintiff had been declared to have right title and interest over the suit land. It is also seen that the learned First Appellate Court have, on consideration of the facts, come to a categorical conclusion that the suit land involved in the instant appeal was duly involved in title suit number 62 of 1992. This being a finding of fact, and there being no perversity shown, this court cannot interfere with the same. Under such circumstances, the third substantial question of law so formulated is not involved in the instant appeal. Accordingly, this court is of the opinion that both the appeals are devoid of any substantial questions of law which are involved in the present appeals, for which the instant appeal, both the appeals stands dismissed with cost quantified at rupees 11,000 each. The petitioner here in the appellant, the LCR sent. Well, Oscar, I tried my best to not to do with your suit, but whether to counterclaim can be done or not. But you being a party out there, that is the biggest problem, young man. And there is some fishy out here with the same deed being executed on the same day. Huh? 3/3/2004, both the same day.
Limited where my mutation case has not been considered, extraction has been solved.
Yes, why are you not considering? Huh? To reject it. Let him file an appeal. See, you are to decide. Decide. This way, that way. 1 month, decide. We dispose it of.
That is my prayer, my lord.
Heard Mr. S. Sharma, the S. Chamaria, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent number 1 and 2. The petitioner herein is agreed by the inaction on the part of the respondent number 2 in not passing the orders in mutation case number 73/2023-24, which have been pending since 2023. What is the mutation case? Huh? Bibit Bhusar. Bibit Bhusar number is the case number. He says about 73.
Whatever case.
Good stuff. Yet it is given Bibit Gusor number 73/A. Bibit Gusor is mutation case number.
Yes,
This court, by an order dated 31/5/2024, had sought instructions from the respondent government as to why no action has been taken in respect to the said mutation case number 73/2023-24. Today, Mr. N. Goswami, appearing on behalf of the respondent, submits that the petitioner are not the patadas, are not the recorded patadas, and as such, their names have not been mutated. Full stop. This court, however, does not understand as to why the respondent authorities, more particularly the respondent number 2, have not passed the order. If it has formed some opinion, the said has to be brought on record by passing the due order, so that the petitioner, if so aggrieved, would be at liberty to proceed, take due course, due steps. The petitioner, the respondent number 2, under no circumstances can keep the matter pending. Under such circumstances, the instant petition stands disposed of with the direction to the respondent number 2 to dispose of the mutation case being mutation case number 73/2023-24 within a period of 1 month from the date of the instant
By
order.
giving us a hearing, my lord, because we have to place the document. By giving us a hearing, my lord.
73/74 within a period of 1 month from the date a certified copy of the instant order is submitted to the respondent number 2. Full stop. It is also observed that in the circumstance that the respondent number 2 has any doubt, the petitioner herein may be necessary clarifications may be sought from the petitioner. This court, however, further grants the liberty to the petitioner to submit the necessary, say, any other document, so that to show that they are entitled to the mutation.
I permission.
Yes, what is this?
Lordship, my revision petition was dismissed for non-prosecution.
The revision petition.
Lordship.
Where?
The tax authorities, before the tax authorities.
Then?
They dismissed, saying that they have issued notice of hearing, but I haven't received any notice in that regard. Immediately after receiving the order of dismissal, I made a representation, which was also dismissed, Lordship. Thereafter, I am before this honorable court, because my statutory right of appeal and revision has been curtailed by not hearing the matter.
Is notice of hearing annexure 2. With reference to, sir, I would like to inform you that date of hearing of the revision petition is fixed on 13/6/2022 in the office chamber of the undersigned. You are therefore requested to appear for hearing on that day. Then what
This is
happened?
the first date of hearing when I appeared.
Then you
after
appeared on
factual-
13/6.
I appeared on 13/6.
You
There
appeared on 13/6. Where is the minutes?
After appearance on 13/6, Lordship, the case was next fixed on
Then this order was passed. The petitioner so-and-so filed revision under section 82 against the assessment order passed by the assistant commissioner.
annexure 3 is the rejection order, Lord.
The dealer has failed to appear on the date fixed for hearing for which sufficient. Now, the earlier order was passed by whom? Joint
By-
Commissioner
By the joint commissioner, is
in the revision petition.
After filing of the revision petition, is the first date which was given 13/6 when we appeared, and the next date was 23/6/22. We appeared before, went to appear before the authority, but that day he was not available in office because he was told that busy with some government meeting in the state secretariat. Thereafter, we had been following for a date with the authorities. But no date was issued to us, and finally this order at annexure 3, page 30 was handed over on 21st of January to us. When we came about this knowledge of this order that it has been dismissed for not prosecution, we immediately filed a representation dated 21/1/23, which is page 31, annexure 4. Here we have clearly stated in paragraph 4 that we, on the next date fix, we tried to appear, but he was not available. We have been following with the officer concerned, but the dealing assistant of the office have been informing us that when the date will be issued, it will be intimated to us. But no date was intimated. Finally, on 21, when we again inquired, we were given with served with a copy of this order dated 12/1/23. And we have specifically stated that these 3 notices which have been referred in the rejection order was never received by us.
How do you send it? Ordinary post. Give him a chance. How does it make a sense?
Otherwise, Lordship, ordinary post is not the procedure, and my office happens to be just outside the office of the Commissioner of Taxes, Lordship.
Very well.
And it's an informal.
Then
procedure which they follow.
I think, Mr. Todi, you don't need to say further. If you say further, then we may hold you that why haven't you inquired all this while? If it is just outside the office of the commission.
Lordship, actually, the informal procedure follows in the office.
Anyway, I think you give a chance on which date. You will take it up at 2. Ask which date from your office will appear, and thereafter you consider. Just take your instructions. We'll take it up at 2 because it's
Fine.
already 1. We dispose it of giving him a chance. You're in. being agreed by the order dated 12th of January 2023, by which its revision petition filed against the assessment order for the assessment year 2016-17 was dismissed for default, have approached this court by filing the instant writ petition. Heard Dr. A. Todi, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gugoi appearing on behalf of the Finance and Taxation Department of the Government of Assam. From the perusal of the materials on record, it is seen that being agreed by the assessment order for the assessment year 2016-17, the petitioner had preferred revision proceedings before the Commissioner of Taxes, Assam. Initially, a notice for hearing was issued on 24th of May 2022, thereby directing the petitioner to appear, thereby directing the representative of the petitioner to appear on 13/6/2022. The representative of the petitioner duly appeared on 13/6/2022, and the matter was fixed on 23/6/2022, on which date it was informed that another date would be fixed and the petitioner would be duly informed. However, the petitioner received no information as regards the date so fixed. Subsequently, an order was received. The impugned order dated 12th of January 2023 was received by the petitioner, whereby it was informed that the said revision petition was dismissed as the petitioner, the representative of the petitioner failed to appear or take steps in the said revision proceedings. It is also seen that the petitioner had also requested the Joint Commissioner of Taxes, Assam, to recall the said order by the communication dated 21/1/2023, which was, however, refused by an order dated 23/2/2023. Pursuant thereto, the instant writ petition was filed. It is noticed that it is taken note of that the respondents have filed their affidavit, wherein it has been mentioned that on the earlier occasion the petitioner had due notice of the revision proceedings. However, subsequently, when the said notice was sent, thereby fixing a date for the revision proceedings, the representatives of the petitioner did not appear, for which the order dated 12th of January 2023 was passed. This court, while hearing the learned counsels appearing on behalf of the parties, has inquired with Mr. B. Gugoi, the learned standing counsel appearing on behalf of the Finance and Taxation Department, as to how the notice was effected upon the petitioner, and as to whether there is any document to show that the service of notice was any document to show that the notice of the date fixed for hearing was received by the petitioner. The learned standing counsel submitted that the notice was sent by simple post, and as such there is no documents to that regard. This court, upon hearing the learned counsels appearing on behalf of the parties, is of the opinion that the petitioner ought to be granted a further chance in the instant matter, further chance to proceed with the revision proceedings for the interests of justice. Accordingly, this court interferes with the order dated 12th of January 2023, as well as the order dated 23rd of February 2023, and directs the petitioner to appear and restores the proceedings, the revision proceedings filed in respect to the assessment year 2016-17 to the file of the Joint Commissioner of Taxes, Assam. The petitioner is directed to appear before the Joint Commissioner of Taxes, Assam, along with a certified copy of this order on 31st of July 2024. The Joint Commissioner of Taxes, Assam, shall thereupon fix a particular date or such other dates as may be required for the as may be fixed for the purpose of adjudicating the said revision proceedings. With the above observations and directions, the petition stands disposed. Yes, what is this?
Plot of land of the petitioner, my lord.
Huh?
This was acquired under the Assam Act for the construction of the Rupnagar Deputy Commissioner's or District Commissioner's office. Now, no compensation was paid. The writ petition was filed. The Deputy Commissioner initially filed an affidavit saying that the proposal has been sent to the requiring department, that is the ZAD department. Then we implemented the ZAD department. The ZAD department also in turn filed an affidavit.
The land has been taken?
The possession is taken in almost 2 years done now.
No compensation, no acquisition.
The acquisition, my lord, the Assam Act notification had come, but then the award has not come because the amount is not sanctioned. The ZAD now says that we have sent it to the finance. The
Who appears for the revenue?
revenue is not a party, my lord. We have collected a party and.
You have made whom a party?
And the ZAD.
Where's the acquisition notice?
Notification, my lord, it's in my petition, my lord.
Huh?
The petition, my lord, is that.
There's an affidavit filed by somebody.
The Deputy
Joint
Commissioner's
Secretary,
affidavit also
General
contains-
Administration Department, would like to submit that an estimate of so and so for acquisition for construction of the office of the Deputy Commissioner Kamrup Metro has been received from the general request. Head of account has been. The department has created the head of accounts. Provided to the head of. Filed on 6th of May 2024. Now, who has done this? The commissioner, what does it say? How can they go for requisition?
My lord, under the Assam Act, my lord, under section 4, the rule for of section 3(1), they gave a notice. And my lord, under section 6, they have to then acquire the land. Over position immediately after the notice, within 15 days of this notice, they took over. And the bill and estimate was not yet prepared. And we filed the writ petition, the Deputy Commissioner forwarded the estimate to the ZAD department for sanction. The ZAD in turn says that we have sent it to finance for the financial approval and the budgetary provision. The budget has not been laid according to the budget, and therefore they are not in a deal. We then in turn, my lord, wanted to include the finance department also as a party. But then the IA that has been filed, my lord, there is some defect, and therefore today it has come with an office note that not be
What
tagged.
about IA business out there? We are not
My lord,
concerned
but
with
then
IA.
essentially it's the collector's responsibility, my lord. Here is the notice.
We have to receive how much amount?
The estimate is of, my lord, 2 crores, 16 lakhs, 3,320.
Now this amount has been received.
Oh, my lord, the deputy commissioner wrote to the ZAD, lordship says, Page 68 of the Deputy Commissioner.
Yes. What is this? What is this type of taking over the land? Return the land. You don't have money, don't take up the land. Yes, finance. What is this type of land? You can't take over the land in this manner. Why you are not paying? And the estimate was sent in the month of May. Then we're not concerned. Then take the land after 2024-25. Monday. Today is what? Oh, Tuesday. No, Friday. It's Friday. Get your instructions on Friday. Sanction, not instructions. Sanction of the finance on Friday. Else return the land. You cannot take over the land. You know it. First of all, how do you initiate Section 3 when you are going for, how can you go for requisition of the land? When you are going for permanent construction of the house? Nothing doing. You know it very well that this land is for construction of the Kamrup Metropolitan DCO headquarters. So, return the land. You make fresh estimate whenever you feel like, when you have the money, then take it. It is something like cutting the cloth without having anything. One should stitch. Friday, sanction. You want the sanction? No, sanction. We are concerned with the sanction. We are concerned with the finance department sanction, and then by Tuesday, disbursement. Wednesday by disbursement. Next week you get the money. Take over the land. If you initiate action, any other action, by way of under the right to fair compensation, or under the old act, or even under this, whatever may be, you cannot take over somebody's possession out there without even paying 80% of the amount. Your requisition, how can you go for a requisition? There is one judgment I delivered on the question of requisition. Whose case I forgot? I delivered one requisition, H.T. Kalla. That is a judgment, na? Supreme Court. H.D. Vora. H.D. Vora is the judgment. And then the matter went to the Constitution Bench. Constitution Bench also said that yes, you cannot. And recently, there is one judgment in 2023 by Justice Ravinder Bhatt. This is an absolutely fraudulent and colorable exercise of power by the departments, including your department, GD, General Administration, GAD. No, not the health department. That is that department. Which one was that? The Adabari matter. There's a Adabari, in Adabari, once you have taken it for the bus stand, there was another plot of land of 8 bighas or 8 kathas or something to the land. Some land was taken over and it was requisitioned in the year 1986, and it was continued there till that day when I passed that order. Yes. It cannot happen. Place the matter on 26/7/2024, on which date the Learned Counsel appearing on behalf of the Finance Department.
Finance, my lord, is not the other part.
Huh? He's for finance.
Is for finance and also for GAD. Finance is yet to be added as a part.
No, JD, they won't do it. Finance has to be there. Nowadays, he's the counsel for finance.
I might have to inflate them, but because some defect in the IML, it could not be listed.
Forget about that. We don't require all these things. You only file the memo of parties.
Okay.
We implement the finance now itself. Allah. The instant writ petition has been filed by the petitioner, being aggrieved by the action on the part of the respondent authorities in unilaterally taking over the land of the petitioner for the purpose of setting up the establishment of the DC establishment or the setting up the office of the Deputy Commissioner, Kamrup Metro, which is a permanent establishment in the land belonging to the petitioners. Full stop. It is seen that from the affidavits on record that the respondent authorities have initiated proceedings under Section 3 for requisition of the land in question and thereby had taken over the possession. It is no longer res intriga that when a land has been taken for permanent purpose and that too for construction of permanent buildings, resorting to requisition proceedings is nothing but a colorable exercise of power. The proper proceedings which ought to have been initiated ought to have been for acquisition of the land. It is also seen from the records that an amount of rupees 2 crores 16 lakhs. It is also seen from the records that certain steps have been taken. And it's also seen from the records that the land has also been acquired in terms with Section 6(1). Thereupon, it is also seen from the records, and more particularly the affidavit which has been filed by the Deputy Commissioner Kamrup Metro, that the land, that notifications under Section 6(1) of the Assam Land Requisition and Acquisition Act 1964 have been issued for the purpose of acquiring the land. Under such circumstances, there should not have been any delay in payment of the compensation. This court also takes note of that the respondent authorities have also come to a finding as to what would be the entitlement of the petitioner. And in that regard, had observed, and in that regard, the General Administration Department of the Government of Assam had made an estimate to the tune of rupees 2 crores 16 lakhs 3,820. It is also seen that the said estimate has been processed to the Finance Department of the Government of Assam for the purpose of releasing of the said amount, for the purpose of granting of the necessary sanction for the release of the said amount. A head of account has also been created in that regard. This aspect of the matter could be seen from the affidavit filed by the Joint Secretary to the Government of Assam General Administration Department on 6th of May 2024. It is also seen that the matter has been pending before the Finance Department from 16/3/2024. Now, even prior to 16/3/2024, inasmuch as it is at the behest of the directions issued by the Finance Department, the head of an account was created on 16/3/2024.
This particular observation.
No. Here it says, in response, the Finance Department of so-and-so dated had created the head of account. Next financial is, this is the financial year.
So I will have the instruction when.
It is also seen that it is on account of the matter pending before the Finance Department. The matter, the amount of rupees 2,16,03,820 had not yet been sanctioned. It is also seen that at the behest of the finance department, the head of account was created on 16/3/2024. And it has been also informed to the General Administration Department that the budget would be provided in the next financial year 2024-25, which is the current financial year. The said affidavit was filed on 6th of May 2024. And there is nothing on record, further on record as to why the amount has not yet been disbursed to the petitioners. It is seen. Under such circumstances, this court impledes the Commissioner and Secretary to the Government of Assam Finance Department as having its office at Dispur, Guwahati, 781006 as the respondent number 5, inasmuch as a response from the State Finance Department would be required. And response by way of instructions would be required as to why the petitioners have not yet been disbursed the amount. Accordingly, this court impledes the Commissioner and Secretary to the Government of Assam Finance Department having its office at Dispur, Guwahati, 781006 as the respondent number 5 to the instant proceedings. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court by tomorrow. And the registry of the court shall, on the basis thereof, make necessary correction of in the cause title as well as also update the same in the CIS. The standing counsel appear for the General Administration Department, Mr. B. Gogoi, is also the standing counsel of the Finance Department. And he accepts due notice on behalf of the respondent number 5 and submits that he would provide the necessary instruction as to why the amount has not yet been disbursed to the concerned respondent authorities so that the further disbursal can take place to the petitioner. List the matter again on 26/7/2024. Liberty given to the petitioner to mention the matter for upgrading. Yes, what is this?
Pilot municipal, no confidence motion.
What happened?
Pilot, in fact, they filed, there is an interim order in my favor. They filed an IA for vacating of the interim order. Thereafter, they filed another IA for deleting the name of 2 of the applicant in that IA for vacating of the interim order.
Tell me what is your case?
My lord. Pilot, what
Why should we go into the small issues?
Absolutely.
Let us have the bigger issue. Tell me.
Absolutely. My lord, what had happened in this case is this, my lord. I am the chairman of Silapathar Municipal Board, my lord. Now, my lord, in the month of December, a no confidence motion was brought against me, my lord. But the requisition for calling a no confidence motion was sent to the deputy commissioner. Therefore, the deputy commissioner thereafter, my lord, directed that a meeting to be held discussing the no confidence motion against me, my lord. Thereafter, my lord, the meeting took place. In the meeting, my lord, the no confidence motion against me did not pass. My lord, they alleges that, my lord, in the meeting, we have stopped their the other ward commissioner from entering the meeting hall, my lord, and there were, my lord, allegations against us, my lord. We have also filed FIR, they have also filed FIR, be that as it may, my lord. Ultimately, my lord, that no confidence motion against me did not culminate. I was the chairman. My lord, against that resolution of whereby the no confidence motion failed, they challenged that resolution before this honorable court, my lord. This honorable court have held that the deputy commissioner has no power to call any no confidence motion, neither does he has the power to direct the municipal administration to hold a meeting for no confidence motion, because under the scheme of the Municipal Act, a requisition for no confidence motion against the chairman is to be served on the chairman, and the chairman within 20 days need to call a meeting. If he fails, then the people who have signed the requisition may call it. That's the scheme under the Municipal Act. So the matter is there. However, my lord, while passing that order, my lord, this honorable court, as a passing remark, had said that there is no bar in calling for a second no confidence motion. My lord, thereafter they called a second no confidence motion. Now, my lord, now this time they have given the requisition to me. I have fixed a particular date for the meeting, my lord. The executive officer writes to me that don't hold the no confidence motion now because the model code of conduct is in force. The elections are there, my lord, and the MP and MLA, who are the ex officio member of the municipal board having the right to vote, are busy in the elections. Moreover, the model code of conduct, you call for a no confidence motion after the model code of conduct is over. The model code of conduct was supposed to be over on 4th of June. Thereafter, my lord, though I called a meeting to discuss the no confidence motion, but thereafter I had to cancel, or to be precise, postpone it. I write to them that, see, the executive officer instructed me to not to hold this meeting now, so I will hold it after the model code of conduct. My lord, they could not hold their nerves, my lord. They went ahead with the no confidence motion and they passed a resolution ousting me from the post of chairman. Now, my lord, I challenged that no confidence, the resolution, the second resolution before this court, and the court gave me an interim order installing me as the chairman, that I will remain as a chairman, my lord. Against that, they filed an IA for vacating the no confidence motion. Now, my lord, this IA was filed amongst other by two persons who, according to them, was elected as a chairman instead of me, and the vice chairman who took the initiative of calling the no confidence motion, the second no confidence motion. Now, my lord, now after filing of the IA, they filed a second IA. The second IA, now these two persons, they have withdrawn from the case. The copy of the IA has been served on me, my lord. It says that they do not want to pursue the case. So that's how the case stands as on date, my lord. My basic challenge to the second requisition was that during pendency of a model code of, during the currency of a model code of conduct, my lord, such a meeting cannot be called in view of a notification issued by the election commissioner. I have annexed a copy of that notification. My limited prayer was that when I moved this petition, that now, my lord, 4th June, now we are in the fag end of July, that any date post 4th of June, to their convenience, let them decide. We'll let them decide. We'll fix the date for discussing the no confidence motion against me, because at the end of the day, my lord, it's a democratic process. I'll have to show my strength on the floor of the house. Now, this is my case, my lord, in nutshell. First motion, first no confidence motion, read petition, finish, my lord. Second no confidence motion, during currency of the model code of conduct, I said post 4th of June, let a no confidence motion be called post 4th of June. Still, if, my lord, they are interested to pursue the no confidence motion, let them send a requisition, my lord, tomorrow. Within 10 days, I'll call a no confidence motion.
Where is that election commission thing?
My lord, may kindly come to page 100. To be precise, 110.
Then
This is the notification. The relevant part your lordship would find at page 122. My lord is there, my lord. Meetings of local bodies, panchayat, municipalities, etc. A read petition number 4766W of 2011
Yes.
of 2011, such and such versus such and such, was filed before the Honorable High Court of Calcutta, seeking a declaration that no meeting of the councillors of Kulti municipality should be held during the period when Model Code of Conduct is in force. The Honorable High Court, by its order dated 11/3/2011, dismissed this petition with the observation that the question would be for the commission. Commission, my lord, here the election commission. Would be for the commission to decide, and further directed that a copy of the order be communicated to the commission. Accordingly, a copy of the order of the Honorable High Court was referred to the commission. Now, third, the commission, after considering the matter, decided that there would be no objection on its part to the holding of the statutory meetings, which cannot be avoided by the municipalities and panchayat and local bodies, subject to the condition that no new policy decision and announcement shall be made in such meeting till the elections are over, and only the decision related to routine day-to-day management issues, and on emergency issues may be taken in such meeting. And here, my lord, emergency, the word emergency meeting, my lord, some hint is given under section 295 of the Assam Municipality Act, which says emergent meeting, emergent situations are those pertaining to the health and safety of the police. Suppose some disease broke out in the town, some spillover, some train, some calamity. These are emergency. No confidence motion by no stretch, my lord, can come within the periphery of these day-to-day management issues, or for that matter, emergencies. And my lord, moreover, my lord, during currency of a model code of conduct, the MP and MLA who otherwise have the right to vote will not be able to attend the meeting, my lord. Therefore, my lord, what we were simply praying is that any date post June 4, agree to any date post June 4, the MLA MP would also be free. Let them call, my lord.
Okay, Mr. Vishwas, the last part is okay. What do you say about the earlier part? That no new policy decision and announcement shall be made in Senate till the elections are over.
Yes. No
What do you say
new,
about-
so no new policy decisions, my lord.
And announcements.
An announcement, my lord, some benefits, some, my lord.
Having a new chairman.
My lord, I did not announce my chairmanship.
They announce a new chairman
That is
after the elections.
not after the election, during, because this was
Anything can happen, but they cannot only pass the order of giving any announcements of a new chairman.
my lord, if subject to correction, my lord, if I understand clause 3 correctly, my lord, clause 3 says the statutory meetings can be held subject to conditions. Now this one, that and only decisions relating to routine day-to-day management.
Isn't this a statutory meeting?
Yes, statutory meeting under 20.
So it
Now,
can
my
be held.
Now, my lord, statutory meeting subject to conditions. My lord will kindly see these, the conjunctions used are and. Statutory meeting, because my lord, these are statutory meetings, no conflict, but for that matter, even emergency meetings are also statutory meeting under this act. Only decisions related to routine day-to-day management issues.
No, that is another issue. We are not concerned with that. Subject to the condition that no new policy decision and announcement of the meeting till the elections are over.
Yes.
So the order of the election, the resolution would be over, can be very well announced after 4/6.
Now, my lord, the resolution, in fact, the resolution which has been taken, that resolution also, my lord, we are challenging the sanctity of the resolution in as much as, my lord, there were no representative of the government present there. Now, my lord, they among themselves, now 2 of them have withdrawn. What had happened is this, because neither the executive officer is the custodian of the proceedings under the Municipal Act post amendment 2024. The executive officer is the custodian of the proceeding. The very executive officer is saying, wait till 4th of June. After 4th of June, you hold it. Their actual purpose was this, my lord. They somehow want to stop the MLA and the MP from voting. because in the last meeting, the MLA and the MP voted in favor of the present chairman. So, in a harsh manner, before
How many MLA or MPs were there?
MLA MP is only two, my lord. One MLA, one MP.
How many votes? How many
14.
total were the votes?
14. Total ward members 14.
Of which there were two MLA MPs.
Two MLA.
One MLA, one MP.
One MLA, one MP.
So it is 12.
12.
How many votes were carried against you?
How many votes? According to the impugned, this, my lord,
How many? So there are 13 members.
13 members.
13 and of which MP MLAs are two.
Two.
So that is 11.
11.
How many members voted against him?
More than half, because it has to be 8 whole number, because if I divide 11, it will be 5.5, that would be 6. 6 plus 1, that would be 7, my lord. So if 7 members vote, my lord, the entire issue is that whether, my lord, under what compulsion, my lord, how this meeting was held, because, my lord, there was no, because in the previous meeting, which the deputy commissioner called, my lord, in that meeting, the executive officer, representative of the government, everybody was there, my lord, present. The simple issue.
Can the executive officer which stall the any meeting called a requisition meeting?
Because, my lord, the executive officer is, in fact, my lord, the language used in the amendment is this, my lord. I'll just one time, my lord. There shall be an executive officer in every municipality who shall be appointed by the state government and shall act as the principal municipal officer of the municipality, and all other officers and employees of the municipalities shall be subordinate to him.
All other?
All other officers and employees of the municipality shall be subordinate to him.
Are you saying the MP and MLA are subordinate to him?
MP and MLA are not the officers of the
The
municipality.
ward commissioners are not subordinate to the or executive officer.
Yes, my lord, I'm not suggesting that commissioners are out of this, my lord. The executive official shall not only be a member of the board, but shall be a whole-time officer of the board and shall have the right to attend all the meetings of the board without any right of voting. Then the executive officer shall be responsible for the custody of all records of the board, including all papers and documents connected with the proceeding of the board, the standing committees and other committees, and shall arrange for the performance of such duties relative to the proceedings of the said bodies as they may respectively impose. My lord, my humble prayer was this, my lord, that, my lord, let them, my lord, let a no confidence motion be held post June 4. It is not a case, my lord, where
Who
I
has
have
filed a writ petition?
filed a writ petition.
What is this application? This is an affidavit. What is this?
That there are 2-3 IS filed by them,
1526 is earlier writ petition.
earlier writ petition. But this could have been solved amicably, my lord. We said that post June 4, call a meeting of a date of their choice. Even today, my lord, I am submitting on instruction, my lord. Let them send a requisition tomorrow. Within, though the statute provides 20 days, within 10 days, I'll call for a no confidence motion meeting.
But there were only 7 persons who were present.
my lord.
And how many people requisition?
Requisition,
Seven.
Your lordship will find the requisition
That's by 7.
by 7. Now, 2 have withdrawn, my lord, by filing an affidavit before this court.
2.
Withdrawn in the sense, they have withdrawn. They were aggrieved by the the interim order, because a vacating petition was filed. And if I read their IA correctly, it says that we don't want to pursue it. That's the language used in the IA. No, they have filed them for wakalatnama withdrawal, not as.
Today's meeting has resolved that by 7 out of 11. Why there are 11 work commissioners?
11 what MP, MLA minus 1 got, he tried
Resigned.
some government service,
He resigned.
resigned, minus, so 14 minus 3 is 11.
He was held on. What was the resolution?
My lord will kindly see the resolution. Your lordship will find at page number 101, it starts. The resolution is the operative part 103. And the requisite and the meeting was fixed by the vice chairman, who is saying that she doesn't want to pursue, on 27, just 2 days prior.
Now, who is the chairman now?
I am the chairman.
No, who is the chairman? As per the resolution.
As per the result, now this is, my lord, there is another catch, my lord, here. Now they take this resolution, they don't appoint any chairman. Now, what they have alleged is this, that on the same day, they had taken 2 resolutions. One at this 10:30, another is at 2:30. That in the 2:30 resolution, they have appointed one J. Kutum, if I'm correct, Jiten Kutum, one J. Kutum as the chairman. Now, interestingly, this J. Kutum has come up with an affidavit saying, I don't want to pursue this case. Now, J. Kutum was appointed as the chairman, resolution was taken at 2:30. Now, my lord, there are certain things, my lord, unconnected threads. Now, the first resolution at 10:30 was forwarded to the deputy commissioner. My lord will kindly see the forwarding letter is at page number 101. On the same day, they forwarded to the deputy commissioner. There is no mention at all of the appointment of the J. Kutum as the chairman. Page 101. On the same day, they forward this to the deputy commissioner. Now, my lord, when this case came up for motion, my lord, page number
No,
101.
it's okay. Now, tell me, where is the notice for calling for a meeting?
Notice for calling for the meeting, page 97. By the vice chairman.
Now, where is it that the other meeting will be held at 2:30?
That is not there.
Next, my lord.
Where?
Together. If we
No. Understood. Where have you enclosed?
Just, my lord.
Where?
Left,
153. No, this is the resolution.
Yes. Notice to.
This is the resolution. Where is the notice? Because your earlier meeting said 29/5/2005, 2024 at 10:30 AM. Where is the meeting for this 153 meeting? The earlier resolution also does not show that you have made it thereupon in the earlier resolution that at 2:30 it will be held. How is it possible that you are going to hold it at 2:30? How will the people know? You fix a time as regards holding the earlier meeting. Fair enough. We are not going to interfere. But as regards the appointment of a chairman, where is the meeting? It can be only by way of a meeting? Where is how did you call for a meeting? Then
Violation of section 41. Section 41 says, if vacancy arises, 45 days notice has to be given. Section 41, subsection 2 Municipal Act.
how do you take care of that? You interfere with the second one of appointing somebody and direct whom? Whom should we direct?
My lord, now this is a situation, my lord. Let there be a no confidence motion. Let the court fix a date. Maybe Friday, Monday. Let there be a no confidence motion in the presence of the executive officer who, by the statute,
Why do we need the executive officer?
because he's the custodian of the proceedings, proceeding books, my lord.
If he does not want to appear, then why should we?
No, my lord, he will appear is because of the model code of conduct. He specifically explained that the only reason is the election is in the corner, my lord.
So
my lord, because the
there was no
election is-
bound. The Municipality Act cannot be taken over by the Election Commission.
No, my lord, because the notification, because they did not challenge that notification before any read court. The notification remains as it. The
Which one?
notification says, my lord, that only day-to-day decision.
No. That notification is does not. Yeah. At best, you can read that notification to that effect that you cannot give the announcement or whatever decision which is made will be prospective post 4/6/2020.
No, my lord, removing me is also a policy decision, my lord. Removing me from the post of chairman. If
So
the
it will be deemed that you have been removed from 4/6 after 4/6, 5/6.
But my lord, by creating a friction because my lord, this deeming provision is not there, my lord. My lord, the source of power is not there that it will be deemed if
Election Commission has lost its force now. We have
absolutely.
nothing to do.
So
with it.
therefore, my lord, what I am praying, my lord,
We direct the authorities who is to appoint. Show me that municipal account.
appointment is to be amongst the chairman. There will be an election amongst the chairman.
So contest in the election.
My lord.
Contest in the election.
My lord will kindly see in the manner how the once a vacancy is created. My lord, there are two things. One is, my lord, when the tenure is over, there will be election by secret ballot, my lord. The different wards will elect commissioners.
Is there a bar if you are removed? Is there a bar for you to participate? Is there a bar to participate? If any chairman or the vice chairman of the board be unable to complete his full term or office or avails himself of leave under 40, the vacancy caused by his resignation, removal by election, the person to be selected shall fill if such vacancy is to be explained by so and so, provided that no person appointed under subsection 2 of the Act, chairman or the vice appointed and
My lord may see section 41, subsection 2.
case of a vacancy in the case of a chairman, so and so, I mean. So the vice chairman, let the vice chairman call for a meeting within 45 days. Contest, fight.
No, no, I am there, my lord. I will, my lord, this is the same thing, my lord, because if a meeting for no confidence is called, in the same, I will have to show my strength. It is also one way of contesting, my lord. If a no confidence motion is called on Friday, I'll have to show my.
No, no, it is apparent. Code of conduct cannot take over that. It is a statutory prescription. No, that is okay. You holding the meeting, but you cannot go for appointment. We interfere with that resolution, direct the vice chairman. Which one?
Second resolution was bought later by means of an additional affidavit filed by them. They were under caveat. Even on the date when I have moved this application, when I have moved this writ petition, they were under caveat. This resolution was not there. We have taken specific ground that this resolution was afterthought. This resolution was bought by means of an additional affidavit. Even they were under caveat when this when I moved this.
Okay, Mr. Biswas, why don't you argue that when the statute categorically says that a 45 days notice is required
Yes.
and a notice has to be issued,
Yes.
is on the way, any resolution taken at 2:30 was non-S without there being a notice.
My lord.
And if it is non-S, you need not challenge it.
Yes.
Argue that.
Oh.
You said it like that. This is non-S, Mr. Sharma. This is non-S. You are the vice chairman. Call for a meeting of
Now
45.
no longer he is the vice chairman.
You are no
Because
longer vice chairman.
Vice chairman, he has withdrawn the wakalatama of the vice chairman. Vice chairman and chairman, both of them has withdrawn.
No. He has withdrawn the wakalatnama, not from the post. And earlier also the vice chairman remains the same.
Yes, yes,
It has been said that it is continued.
yes,
In fact, they should have taken the decision then and there.
yes.
Anyways, you can't appoint anybody. So there is no bar for the petitioner to participate. No bar. Huh?
Fine.
As per what provision? But shall not take any important decision.
Well, these are all allegations. There is nothing in the pleading.
And anyway, shall not take any important financial or year, only day to day.
My lord, may I subject one? My lord, let the interim order, because there is an interim order operating, my lord, instead of making any stopgate arrangement, my lord, already an interim order is operating of this court. Let this interim order be continued for another 10 days. Let this court fix a date. I am open to tomorrow morning itself.
For what?
For the date to elect a chairman. Let it be tomorrow, day after tomorrow, any date.
Elect the chairman. Why should you be continuing? It's absolutely wrong.
Because, my lord,
On the face of it, it
my lord,
is wrong.
because my lord,
You have given that the court was persuaded to understand that when there is a model code of conduct, you cannot. The law is very clear. It can be. And in fact, without going into the division bench judgment also, it is clear. It can be held. Model code of conduct cannot override the statutory prescription. Don't know with this.
because, my lord, my lord, because the result would have been absolutely otherwise had the MLA and the MP.
Then also we can't help it. It will be 7 against 11.
My lord?
7 against 13.
No, but they will have to, had it with 13, they will have to be more than half.
Obviously, it is 7. They have 7. That is why I asked him.
Also. Committee who is
But, because my lord, at the end of the day, my lord, if
Your submission was good for a motion, not for final disposal. Let me dictate.
my lord will give, at the end of the day, your lordship is giving me an opportunity to
Contest.
contest.
Right out. Shall during the annual. You have to call the meeting within 45 days from the date the vacancy arose. The vacancy arose at on that date. There he was going on an interim. That's another aspect of the matter. But the vacancy arose then. So this is the 45 days. So you are to call within 45 days. Means you have to complete the entire formalities within 45 days. Huh? No, court's interim order would not. Yeah, but anyways, hold it within 15-20 days. And until then, don't take any decision, major decision. Otherwise, you are. But as of now, the prescription of 45 days is over. Thereby, this court is enlarging it in view of this.
But let a date be fixed by this court, my lord.
What?
Or my lord.
They are to complete within 45 days.
Now, my lord, these 45 days will run from 29th or from, my lord, let it be within a span of 7 days, my lord.
Oh, you have no other business here. Your interim order also doesn't good. It is notwithstanding the order passed by a hearing, the petitioner will not assume the office of the chairman to take any policy decision in any meeting or in any financial matters, save and except where the participation of the petitioner is necessary as a joint signatory along with the executive officer.
Absolutely.
Your situation is something
My
like
lord, this mat-
the
my
Supreme Court order in the case of the Delhi CM.
No, my lord, my lord, my lord, this matter could have been, my lord, this matter could have been settled way back in the month of June. If they would have agreed one liner, that fine. On 4th of June, you have problem, my lord, let it be on 6th of June. This matter would have, we are on the fag end of, if they have majority of the ward commissioner, if was, I mean, the way they are saying that is in their favor, if that would have been the case on 6th of June, by now, her chairman, vice chairman, or Mr. Kutum or anybody would have assumed the office. Their entire, the modus operandi, the entire purpose is somehow stop the MLA and the MP. Let it be before the election. 2 days notice was given, my lord.
Of?
My lord, we'll see on 27th, this meeting was called by the vice chairman. They write to me, I call a meeting, then the executive.
For removal, which is the provision?
28.
Huh?
28 read with 43. 28 read with 43 are the
An
provision for removal.
elected chairman or AM may be removed from his office by a resolution of the
At a meeting specially conveyed. Now, my lord, special meeting, your lordship will find at page 43. My lord may skip subsection 3.
Huh?
Subsection 3 is not relevant for this case, my lord. Only 28 subsection 2 is relevant. And this has to be read with section 43.
how notice is to be issued.
Because
Shall meet
subsection
or
2
at
says
least the transaction of
meeting specially conveyed, that is special meeting.
where
My lord, section 28, subsection 2, the last line. Whole, not more than half of the whole number of commissioners shall have given their votes at a meeting specially convened. Specially convened. Now, special meeting and ordinary meeting, your lordship will find at page 43. Sorry, not page, section 43.
but there is no period mentioned.
My lord, if the subsection 3, section 43, subsection 3, my lord, may kindly come. My lord is there at subsection 3. If the chairman or the vice chairman fails to, my lord, no, the chairman or in his absence, the vice chairman may call for a special meeting wherever he thinks 20 days is there, my lord. The chairman or the vice chairman fails to call a special meeting to meet within 20 days. Subsection 3, my lord, is there. If the chairman or the vice chairman fails to call special meeting to meet within 20 days, after any such requisition has been made, the meeting may be called by the person who signed. Yes, for the person who signed the requisition, the second meeting, my lord, there is no specific date. But my lord, if the chairman is given 20 days, there has to be some rationale, my lord, at least 7 days, 5 days. What was so sacrosanct about that date?
Mr. Biswas, I don't have any opportunity to change this. Mr. R.P. Sharma may have in the legislative assembly.
Parliament.
For me, I don't have. Yes. Don't come up with that submission. Done.
That was by me. Then I cancelled it. Then you, again, you.
Anyways, let me come back. I'll dictate it.
The currency of model code of conduct. This is the reason the court has given. Because in this case, the election commission way back in a letter in 2021 have clarified this issue. Now the present writ petition is based on a notification of 2024. Because my lord, this judgment, just now I have come across this judgment, my lord. So during this break, I read this particular paragraph. I could see that in this case, my lord, there was a letter where the election commission has clarified. The judgment of Justice Ujjwal Bhuiya, my lord, paragraph 8, the learned senior counsel relied on that, my lord. Para 8 subpara, my lord. As to why the court leaned in favor of the fact that a meeting can be held.
Yeah.
There was Because my lord,
Which para of
para 8 of this judgment. अपने लिखे ना this Himanshu Roy versus State of Assam. A copy has been given to your lordship.
No, this is exactly the same. See, read it. Totally pura.
Yes, regarding holding of special meeting to discuss no confidence motion, what the model code of conduct was it when the model code Election Commission of India, by its letter dated 5/4/2011 had clarified that there would be no objection on its part to the holding of statutory meeting by municipalities and panchayat during the period when the model code of conduct is in force, subject to the condition that no policy decision should be taken and the announcement in such meeting. Calling of special meeting is provided under the statute. It was a meeting to discuss no confidence motion against the chairman. Question of discussing any policy did not arise. Therefore, such meetings are not prohibited during the period when the model code of conduct was in force, as clarified by the election commission itself.
So this is exactly what it is there here also.
Only the dates I wanted to show, rest up, my lord.
Heard Mr. M. Biswas, the learned counsel, appearing on behalf of the petitioner. Mr. R.P. Sharma, the learned senior counsel, appear. Private respondents. And Mr. Who appears for the housing and 1, 2, 3, 4, and 5. 5 also, na? No. M. Biswas and Goswami appears after the respondent number 1 to 4. 4. R.P. Sharma, the learned senior counsel, assisted by half of the private respondent. Instant requisition has been filed challenging the no confidence, challenging the minutes of the meeting of the special minutes of the special board meeting held on 29/5/2024 at 10:30 a.m. whereby the petitioner, who was the chairman of the what is this board, Silapathar Municipal Board, was removed. The facts leading to the filing of the instant writ petition is that the petitioner herein was elected as the chairman of the Silapatha Municipal Board or Corporation Board on 12/4/2022. It is relevant to take note of that Silapatha Municipal Board consists of 12 elected ward commissioners and 2 ex officio members who are the concerned MLA and MP of the member of Leicester MLA and the MP. It is an admitted fact that out of the 12 elected ward commissioners, 1 elected ward commissioner had resigned. a letter was issued on 1/12/2023 by 7 ward commissioners requesting the Deputy Commissioner Dhemaji Town to terminate the petitioner from the post of the chairman, no?
Chairperson, lady.
Chairperson. In pursuance to the said communication, the District Commissioner Dhemaji, by an email dated 12/12/2023, directed the petitioners to convene a board meeting within 15 days from the receipt of the said letter. In pursuance thereto, a meeting was called on 2/1/2020. A meeting was called on 5/1/2023 at 2:30 p.m. The said meeting was decided in favor of the petitioner, and thereupon a challenge was made on 5/1/2024.
The meeting highlighted.
Earlier meeting was on 5/1/2024. You have written as 23. The same meeting was decided in favor of the petitioner. Being aggrieved, a writ petition was filed before this court, which was registered and numbered as WPC number 76/2024 by the private respondents. Who filed it?
A private respondent of the industry. They have filed it.
Now you filed it on, you filed 76.
That is, I have withdrawn it.
Why did you file it?
I filed it challenging the power of the deputy commissioner to call for the meeting.
But you called for
I
the meeting.
have withdrawn it because, my lord,
Being
ultimately,
aggrieved, the private respondents filed a writ petition which was registered and numbered as WPC number 168/2024. The said writ petition was disposed of by the judgment and order dated 29/4/2024, holding inter alia that the deputy commissioner had no jurisdiction or authority to call for a meeting. However, taking into account the provisions of the Assam Municipal Act 1956, this court granted the liberty to the private respondents to take steps for calling for a special meeting in accordance with the provisions of the Act of 1956. For a no confidence motion against the chairperson and or the vice chairperson, if so desired.
I'm sorry to, my lord. My lord, no liberty as such was given. The line exactly is at page number 42. It is an observation on law, page 42, para 17.
Okay, no
Bottom.
problem.
That's it.
In accordance thereto, pursuant thereto, the private respondents, who are 7 in number, submitted a request for convening a special meeting under section 28 of the Act of 1956. for discussion of no confidence against the chairperson. Full stop. The petitioner, upon receipt of the said communication, informed the executive officer of the Silapatha Municipal Board that he has called the meeting at 11 a.m. on 24th of May 2024. Pursuant to the said requisition so made. The executive officer, on receipt of the said communication issued by the petitioner, informed the petitioner by the communication dated 25/2024 that in view of the Lok Sabha elections 2024 and the model code of conduct being operational, no such meeting should be held till 4th of June 2024. And the petitioner was accordingly directed to cancel or withdraw the special meeting, which was scheduled to be held on 24th of May 2024. Immediately on receiving the said communication from the executive officer of the Silapatha Municipal Board, the petitioner, by the communication, informed the various ward commissioners about the cancellation of the said meeting. It is also seen that on 23rd of May 2024, the executive officer of the Silapatha Municipal Board also informed the chairperson, the vice chairperson, as well as the ward commissioners of Silapatha Municipal Board that he advised against the convening of the special meeting on account of the model code of conduct, and that he would not be able to join the meeting in connection with the Silapatha Municipal Board. The seven private respondents, the private respondents thereupon, on 27th of May 2024, requisitioned another meeting on account of the failure of on the part of the petitioner to hold the meeting as per the requisition, and fixed 29th of May at 10:30 a.m. of May 2024 at 10:30 a.m. to discuss the no confidence motion against the chairperson, Silapatha Municipal Board. This aspect of the matter was also duly informed by the vice chairperson of the Silapatha Municipal Board to the chairman, to the petitioner, by the communication dated 27th of May 2024. On 29th of May 2024 at 10:30 a.m., the special board meeting was convened, wherein the private respondents herein had duly participated. In the same meeting, it was decided by the 7 persons present that the petitioner is required to be removed, and decided that the petitioner be removed from the office of the chairperson of the Silapata Municipal Board. Being aggrieved by the said resolution so taken in the special body meeting held on 29th of May 2024 at 10:30 a.m., whereby the petitioner was removed from the post of the chairperson of the Silapata Municipal Board. The petitioner approached this court and filed the present petition. This court, by an order dated 31/5/2024, issued notice and further state the said resolution dated 29th of May 2024 at 10:30 a.m. insofar as the termination of the petitioner as chairman / chairperson, and directed that the said shall not be implemented without the leave of the court. It was also made clear by the order by the same order that notwithstanding that the petitioner will not assume the office of the chairperson to take any policy decision in any meeting or in any financial matter, save and except where the participation of the petitioner is necessary as a joint signatory along with the executive officer of the Silapata Municipal Board. The record reveals that the private respondents have filed an affidavit in opposition, thereby supporting the meeting held on 29th of May 2024 at 10:30 a.m. and justifying that there was no bar in holding the said meeting. It was also brought to the notice of this court by filing the said affidavit that on the same day at 2:30 p.m. another meeting was held, whereby one Sri Jitendra Kutum was elected as the new chairperson of Silapata Municipal Board. The said affidavit was filed on 12th of June 2024. However, no reply to the said affidavit has been filed by the petitioner. The record further reveals that on 19th of July 2024, an affidavit was filed by the District Commissioner Dhemaji wherein it was mentioned that in terms with section 11 bracket 3 small a bracket close of the Act of 1956, the member of the House of the People as well as the Legislative Assembly of the state of Assam representing the constituencies which comprise fully or partly the municipal area shall be the ex officio chairman of the board. And under section 25 of the Act of 1956, both MP and MLA were also considered as commissioners of the board. It was also mentioned that in view of the currency of the model code of conduct, the chairperson of Silapatha Municipal Board was requested to cancel or withdraw the special meeting by the executive officer Dhemaji. This court also duly takes note of that an interlocutory application was filed by the private respondents for vacation or modification of the orders so passed by this court on 31/5/2024. However, the said application was withdrawn on 18/7/2024. Mr. Sharma, one thing is there where election commission's notification is there, it is not a bar. No quarrel with that. But what do you say about both the district commissioner and the executive commissioner officer directing the chairperson to do so? They should not, but they have. And it is under such circumstances they had to. How do you take care of that situation? That the petitioner now is being compelled by the district commissioner as well as the executive officer not to hold it. Understood, they cannot, but they have. Then can you put the blame on the petitioner? Hmm? Now, how will the petitioner call? He had duly called it, but he has been asked by the executive officer not to go ahead. And the district commissioner also files it by way of an affidavit that look here. But isn't the petitioner now compelled not to hold it? Hmm?
My lord, the consequence of disobedience of this order is at section 28 subsection 3. I can be removed not only as a chairman, but the government has the power to remove me even as a commissioner if I do not obey their orders. Section 28 subsection 3.
But you see, has been persistently omitting or refusing to carry out. Persistently. Persistently means continuously.
Absolutely. More than once repeatedly.
Yeah. And lawful orders, can that be said to be lawful? When the these people have no business out there.
Now, my lord, we cannot outrightly say that executive officer does not have any business because the law says that the executive officer has the overall control of the municipal board.
No, no, no. He does not have any control over the meetings.
He does not have any control. He cannot vote in the meeting.
No, no, he does not have any control over the meetings. Where is it that the executive officer has any say over the meetings?
My lord, the executive officer shall, now my lord, in every meeting, suppose this minute has been drawn, my lord. Now, this minute is a part of the proceeding. Now, my lord, who is the custodian of this
Forget
proceeding?
about the custodian. We are not concerned
My
with the
lord,
custodian.
Then, my lord, the executive officer, what the statute says is this. There shall be an executive officer in every municipality who shall be appointed by the state government and shall act as the P in capital, principal municipal officer. Principal municipal officer of the municipality, and all other officers and employees of the municipality shall be subordinate to him. The executive official shall not be a member of the board, but shall be a whole-time officer of the board and shall have the right to attend all the meetings of the board without any right of vote.
He has a right to attend.
Right to attend.
But he doesn't have, he has no business to direct.
Yes, my lord,
the board.
absolutely. But my lord, the fact remains, my lord, these are strong words used by the statute, principal municipal officer.
So what?
Now, my lord, the principal municipal officer
These are not officers.
no, the executive officer.
Are these commissioners the officers? No. They're not the officers. They're elected people.
But once, my lord, the executive officer has with this legal, my lord, sanctity, my lord, if he directs, my lord, the chairman will naturally, my lord, that therefore, my lord, what I was, my lord, praying is this, my lord, that let there be a no confidence motion, maybe within 5 days, 2 days, tomorrow morning. Let them show their strength on the floor of the house. If I can't show my strength, I go. It's a democratic process, my lord. I cannot be adamant or stubborn that I'll remain forever. No, my lord. But if because this entire process, there is something, my lord, there is some shadow looming large. Now, who will, my lord, vouch for the correctness of this meeting? Two persons, the vice chairman and the chairman, my lord, have not read the affidavit filed by the chairman and the vice chairman in that IA. My lord, will see the averments. They say we don't pursue it now. So what is the correctness of this? Whether they have actually signed, whether this was signed in their home, in their chamber. My lord, will see the IA which they have filed in this, because it is on record, my lord. A fresh IA. The IA number is 2166. para number 2. They don't wish to pursue. Whether at all these signatures in this minute were in a meeting or it was drafted beforehand and circulated, because there was no independent person present. Unlike the first meeting where representative of the government, two representative of the government, deputy commissioner's representative were present. That is probably why, my lord, the statute says that the executive officer may attend the meeting, so that there is some independent person.
Show me the amendment.
This is the amendment, a copy of that. It will over. My lord will see the amendment to section 52, page number 2221 of this gazette notification.
There is the power of the board.
Power of the board.
56.
The amendment I received.
This has been amended.
Yeah, Dada, sir,
52 has been amended. 52 appointment of health officer has now become different. For section 52, the appointment of the executive officer. 53 has been, what has happened to 53 now? 53. 53 has become, now 52 has become 53.
My lord, the power of chairman, your lordship will find at section 37.
Now you see this power under 53(2) earlier. The executive officer shall function under the overall control of the board and under the direct supervision of the chairperson. That is no longer there. This earlier, this has undermined the status of the executive officer. Now this is no longer there. So he does not become subordinate to the chairperson. That power has been removed. That he will be subordinate to the chairperson. Hmm? Now, earlier it was there. The executive officer shall function under the overall control of the board and under the direct supervision of the chairperson. Now, this aspect is no longer there. He has no business.
Probably the thing which, my lord, it is not a case, my lord, where the executive officer is exercising any voting right or influencing the ward commissioner to vote for a particular candidate, or neither he is calling for. Power.
Any meeting.
Ah.
But not this.
The legislature in its own wisdom has excluded this, omitted section 53 subsection 2.
Now you see, the earlier judgment delivered by Justice Surana makes it clear that these district commissioners and anybody has no business, more particularly paragraph 11. In fact, that was your submission there, which, no, your submission in the earlier petition, whereby you were saying the learned senior counsel, I think you appeared out there.
Yes, it's same council, same set of councils.
You appeared, na? Yes. You submitted the learned senior counsel for the petitioner contended that in view of the provision of 296 of the Assam Municipal Act, the district commissioner has supervisory power over the municipal board constituted under the Assam Municipal Board, and therefore the said authority has the sanction of law for issuing letters to the chairperson and the vice chairperson of the Silapatha Municipal Board to hold special board meeting for no confidence motion. We are unable to accept the said submission in view of the provisions of section 296, which does not grant any power to the district commissioner to issue direction to either the chairperson or the vice chairman to hold the meeting to discuss the no confidence against the chair. The provision for removal of the AI is contained in 28 and has been quoted here. It is stated that the barred by the learned counsel from all sides that Assam so and so, the words not less appearing in so and so has been deleted and the words more. From the scheme of so and so, the chairperson or the AI is required to call. So in view of this, nothing I got. Okay, chal. I've heard the learned counsel appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondents. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, submitted that in the instant case, the petitioner here, being the chairperson, was not adverse to calling for the meeting. However, it was on account of the direction issued by the executive officer of the Silapatha Municipal Board, as well as also by the district administration, as would be seen from the affidavit filed by the respondent number 3, that the petitioner had cancelled the meeting to be held on 24th, which was scheduled to be held on 24th of May 2024. The learned counsel submitted that the petitioner, that this court may fix any date, and the learned counsel further submitted that the election commission had also issued a communication on 24th of on 2nd of January 2024 in respect to the meetings of the municipalities and panchayats, and observed and directed and decided that there would be no objection on the part to holding of the statutory meeting, which cannot be avoided by the municipalities and the panchayat and other local bodies, subject to the condition that no new policy decision and announcement shall be made in such meeting till the elections are over, and only the decision related to routine day-to-day management issues and on emergency issues may be taken in such meetings. The learned counsel for the petitioner further submits that this is a case which would not fall within the exception to hold the meeting during the period when the model code of conduct was in force. On the other hand, Mr. R.P. Sharma, the learned senior counsel, appearing on behalf of the private respondent, submitted that the petitioner was issued the requisition on 6/5/2024 for holding the meeting in question. However, the petitioner, that is what I said. That is what I said. The petitioner was issued the notice here. You see when the order comes. Petitioner was issued the communication on 6/5/2024 for requisition for on 6/5/2024 for calling the meeting. Full stop. The petitioner did not call for the meeting. And the petitioner though called for a meeting on 24th of May 2024, but subsequently cancelled. It was under such circumstances the meeting was called in terms with section 43. By the meeting was called under in terms with section 43(3) of the Act of 1956, and as more than the majority had voted against the petitioner in favor of the no confidence against in favor of the no confidence and against the petitioner, the question of interference with the minutes of the meeting dated 29/5/2024 at 10:30 a.m. does not arise, ought not to be. The question of interference with the minutes of the meeting dated 29/5/2024 at 10:30 a.m. ought not to be made. The Learned Counsel, Senior Counsel further submitted that on the very date at 2:30 p.m., another meeting was held, on which date, whereby one Jiten Kutum was appointed as the chairperson of the Silabata Municipal Board. And in that regard has referred to the said minutes which have been enclosed to the affidavit in opposition as Annexure B. Per contra, Mr. M. Buswas, the Learned Counsel, Mr. M. Buswas, the Learned Counsel, appearing on behalf of the petitioner, rejoining to his earlier submission, submitted that the meeting dated 29/5/2024 at 2:30 p.m. is on the face of it non-honest and is completely contrary to the provisions of the Act of 1956. The Learned Counsel drew the attention of this court to section 28.
41(3). 41(3).
Have referred to the area of section 41(2) of the Act of 1956, which stipulates that a meeting for calling for a meeting for election of a chairperson, the notice, the such meeting has to be issued within 45 days of the occurrence of the vacancy. Full stop. He submitted that there was no notice whatsoever issued, and the same would be apparent from the perusal of the materials on record. Full stop. The Learned Counsel submitted that the said meeting, which was held on 2:30 p.m., was nothing but 2:30 p.m. on 29/5/2024 was nothing but an afterthought, and as such is required to be to be rendered as non-honest. Next. This court, before deciding the issues, had put a specific question upon a query upon Mr. R.P. Sharma, the Learned Senior Counsel, appearing on behalf of the private respondents, as to whether whether the decision taken in whether the meeting dated 29/5/2024 at 2:30 a.m. was preceded by any notice, or to that effect, there was any resolution, any agenda for appointment of an chairperson in any of the notice. Huh? PM code. The learned senior counsel on instruction submits that the meeting which was held on 29/5/2024 at 2:30 p.m. was not preceded by any notice, was neither preceded by any notice, nor there was any agenda for appointment of a fresh chairman. In the backdrop of the above, let this court now take into consideration the respective submissions. The first issue, and the respective this court, in view of in the backdrop of the above, the following points for determination arises for consideration: whether the impugned minutes of the special board meeting held on 29/5/2024 at 10:30 a.m. requires any interference. Number two, whether the minutes of the special board meeting held on 29/5/2024 at 10:30 a.m. requires any interference. Number three, what relief or reliefs the parties herein would be entitled to. Next. The first point for determination, which have been formulated herein above, is in respect to the special minutes board's meeting, which was held on 29/5/2024 at 10:30 a.m. It is seen that on 6/5/2024, the private respondents, who are 7 in number, had made a requisition to the petitioner for calling for a meeting to discuss the no confidence of the chairperson of the Silapata Municipal Board. The petitioner herein, though, convened the meeting on 24/5/2024 at 11 a.m., as would be seen from the records, but subsequently, on the instructions issued by the executive officer as well as the district administration, the same was cancelled. The question arises as to whether the same ought to have been cancelled. The reason assigned by the petitioner is twofold. First, that there was a direction issued by the executive officer of the Silapata Municipal Board, and the second, that there was the model code of conduct was operating till 4/6/2024. This court duly takes note of the observations made by the learned. This court had duly taken note of the provisions of the Act of 1956, which have been amended by the amendment carried out by the Assam Municipal Amendment Act 2024, which came into effect from 14th of March 2024. Full stop. A conjoint reading of the provisions of the Act of 1956 as well as the amendment so carried out nowhere shows that the executive officer has the authority to intermeddle with the proceedings for removal of the chairman or the vice chairman in question. In this regard, this court finds it very relevant to take note of the observations so made by the coordinate bench in the judgment, in its judgment dated 29 in its judgment dated 29/4/2024, passed in WPC number 168/2024, wherein 24 footstep. Paragraph 11 of the said judgment, paragraph 11 and 12 of the said judgment being relevant is reproduced herein under. Footstep. From a perusal of the from the perusal of the observations so made by the coordinate bench of this court, it is apparent that neither the district administration has no power to interfere with the proceedings for removal of a chairperson or a vice chairperson. The provisions of the Act of 1956 as also does not show that the executive officer of the municipal board has any control over the removal of the chairperson or the vice chairperson or holding of such meeting. The next issue and the next point which arises therefore is as to whether the model code of conduct which was operating till 4/6/2024 and was made the basis by the executive officer to direct the chairperson, to direct the petitioner to cancel the meeting, could have had any would have had any impact on the provisions of section 28 now 23 or 28 on 28 28 no procedure on 28 no on section no not that call for is where you said
43. Ordinary and special meeting, 43.
In the proceedings under 20 proceedings for removal of the chairperson and the vice chairperson under section 28. Mr. R.P. Sharma, the Learned Senior Counsel, submitted that the said issue is no longer res intriga, taking into account the said similar issue has already been decided by a coordinate bench of this court in the case of Himanshu Roy versus State of Assam, reported in 2019 5 GLT 796 and referred to paragraph number 8 of the said judgment. He further submitted that the said judgment passed by the coordinate bench has also been upheld by the division bench of this court in its a division bench of this court, in writ appeal number 182 of 2019, in a judgment and order dated 30th of September 2019. This court, taking into account this court have perused the instructions issued by the Election Commission of India dated 2/1/2024, on which reliance was placed by the learned counsel for the petitioner. And more particularly to clause Roman 7 of the said instructions. It is seen that the coordinate bench of this court have taken a parametry instructions which was issued on 5/4/2011 and held that a meeting for the purpose of removal of the chairperson, a meeting to discuss the no confidence against the chairman, is not prohibited during the model code of conduct was in force. Paragraph number 8 of the said judgment passed by the coordinate bench in the case of Himanshu Roy, Supra, is reproduced hereunder. In view of the above, it is clear that the respondent authorities, the petitioner, in view of the above law as settled by the coordinate bench of this court, which have been upheld by the division bench, it is clear that the model code of conduct could not have come into the play in deferring of the meeting which was requisitioned. The entire edifice of the directions of the executive officer was also on the basis of the model code of conduct. The affidavit which has been filed by the respondent number 3 is also on the model code of conduct. Therefore, the justification for not holding the meeting by the petitioner on the basis of the model code of conduct was misconceived and was not at all tenable. The consequential effect of the above declaration is that the meeting which was held on 29/5/2024 at 10:30 a.m. cannot be said that it would require any interference. More so, the same appears to be in consonance with section 41(3) of the Act of 1956.
43.
43?
41 is the second one, 2:30 p.m.
No, 41.
41 would come for the.
No. 43(3) of the Act of 1956. Under such circumstances, in that view of the matter, the first point of determination is decided, thereby holding that the impugned meeting or impugned special board meeting held on 29/5/2024 at 10:30 a.m. does not require any interference. Next. The second point for determination arises as to whether the special board meeting held on 29/5/2024 at 2:30 p.m. requires any interference. It is seen from a reading of section 41(2) that upon the removal of the chairman, the vice chairman is required to call for a meeting to complete the election within 45 days of the occurrence of the vacancy. For calling for a meeting, it is the requirement that a notice has to be issued. Admittedly, there was no notice issued. Even a perusal of the minutes of the special meeting held on 29/4/2024 at 10:30 a.m. also do not show that there was a deferment of the said meeting to discuss as regards the appointment on the selection of the chairperson. There was also no agenda for doing so. Under such circumstances, it is seen that the second meeting, which was held on 29/4 to 29/5/2024 at 2:30 p.m. is not only contrary to Section 41(2) of the Act of 1956, but also goes against is contrary to Iman, and as such has to be regarded as non-est. This leads this court to the third point for determination as to what relief or reliefs the parties herein would be entitled to. Taking into account that the petition, this court have not interfered with the minutes of the meeting held on 29/5/2024 at 10:30 a.m. The removal of the petitioner from the chairperson of the Silabata Municipal Board is not interfered with. It is seen that the vice chairperson, has to now, in view of section, the vice chairperson has therefore is required to fill up the vacancy of the chairperson in accordance with section 41(2) of the Act of 1956. The same was required to be done within a period of 45 days from the date on which the vacancy has arisen. This court have also taken note of that the vacancy arose on 29/5/2024. And more than 45 days have passed, and in view of the interim orders passed, the said resolution dated 29/5/2024 at 10:30 a.m. was not put to effect. Be that as it may, the chairperson, the petitioner also could not render any, be that as it may, the Silabata Municipal Board was not functioning with a proper chairperson all this while. Under such circumstances, though it is the mandate of holding the for filling up the vacancy within 45 days, this court directs the vice chairperson of the Silabata Municipal Board to fill up the vacancy by calling for a meeting on or before 21st of August 2024. This court further observes that during this period, in terms with section 39, the vice chairperson would be in a position to function, to exercise the powers of the chairperson. However, as there are various disputes, this court, for the ends of justice, observes that though the vice chairperson would be exercising the powers, will be performing the duties of the chairperson, but the same being temporary, no major decisions would be taken which would have any impact on the policy as well as the financially on the Silapatha Municipal Board.
That the petitioners may also contest, his case may also be considered for the post of chairman.
Not considered, may participate.
May participate in this case.
Not considered. Considered is for the authority. It is, however, made clear that the removal of the petitioner from it is made clear that the non-interference to the minutes of the meeting dated 29/5/2024 at 10:30 a.m. shall not preclude the petitioner to participate in the election to the chairperson of the Silapatha Municipal Board.
Participate, well, what happens well, last time also because of this one line observation, this second meeting came on. Participate, my lord, I do not know how this, because participation means as a candidature, whether the, my lord, can it be like this, my lord, subject to what your lordship says? That needless to say that it will not be a bar for the petitioner to be as a candidature for the post of. Because well, participation, my lord, these things happens, my lord. Why he is scared of this, my lord? This is the intention of the court. Court is saying that my candidature can also be considered in case the commissioner wants me to be chairman.
Shall participate in the election. What is there? What else do you want? Participate in the election to the post of the chairperson. What is there? What word do you want? I can't use the word considered. Considered is a different word.
Contest, participate stroke contest.
Or contest.
Participate stroke contest so that.
Shall contest. Participate shall contest.
While your lordship was dictating while framing the issues, in issue number 2 also, instead of 2:30, it is dictated as 10:30. I did not interfere with.
But issue number 2 is 2:30.
2:30.
That will be correct.
Correct.
21st of August, huh? Giving you time 21st of August to hold the meeting.
Meeting 21st of August.
Not meeting, it's to hold the meeting for the election. So 20 days time is given. There is no meeting. It is not required. I don't think there is a requirement of any days. 20 days is not there. But then also you have a pretty long time. Today is 23rd, 21st time given.
Number 6 for the. Say that item numbers 11 and 12 may not be taken up today. Other side is not.
11 and 12 adjourned.
Item number 6, the part out matter,
Which one?
regarding the application of section 5 of the Limitation Act in the condonation of delay in DRT matter. It takes some time, my lord.
We have time till 15 minutes. Who is there? You are there?
Maybe fixed on any other day, my lord. If your lordship is so pleased.
Don't want to do, don't want to do. Whoever wants to do, stand up and tell me. Mr. Jain, you want to do your matter? Mr. Jain, you want to do your matter? Mr. Jain matter.
My lord, a date may kindly be fixed in this matter, my lord.
Huh?
Item 6, a date may kindly be fixed, my lord.
Why you didn't want to do the matter? Limitation Act for what?
Petition, application of, my lord, section 5 of Limitation Act in condoning delay in filing the petition before the TRT. What that matter, my lord,
Under section 17 of
Or in view of the Calcutta judgment? And the
Maybe
matter is pending with the Supreme Court. What has happened?
but I do not know to happen such Supreme Court cases, my lord. Still pending so far as I know. Decided here.
The Parthad matter. If it is Parthad, we need to finish it off as early as possible.
Yes, maybe on 1st of August, my lord. 1st of August.
When?
1st of August.
First of August, there are a lot of matters. 8th of August.
8th. Like,
Yes, Mr. Jain, what is your matter? Arisi? Here for the respondent.
Pending lordship, the PP Datta here,
Who?
the PP Datta lordship.
What is this matter about? Whole matter. Third day challenging. Judgment? Yes.
Lordship, in this case, this file, brief has been taken over from us, Lordship.
Huh?
A brief has been taken over from us, Lordship.
No, I'm asking you, what case do you have? What is your case? Your case. You want an allotment.
Lordship.
Why?
If this case, the Lordship, I'm not in a position to submit, Lordship.
Did the matter come up in the list?
Yes, Lordship,
Yeah.
but file has been taken over from us, Lordship. We have handed over the brief, Lordship.
Who?
Lordship.
You have handed over the brief. When? When?
On 12/4/2024,
21.
12/4/24, Lordship. Appeal.
Then they knew. We dismiss it for default. This is by Rubul Ali.
Lordship, I am not in the case, Lordship, because it was engaged by the chamber of RJ Bodloi. After demise of RJ Bodloi, that Rubul Ali has handed over the brief to him. I am just informing Lordship.
You are who?
I am for the appearance, I am appearing on behalf of PJ Mohanta. PJ Mohanta was engaged, Lordship.
Have you filed wakalatnama?
My Rupalatma is not there, Lordship.
None appears. Dismissed for default. That over. You are nobody. You have not signed wakalatnama. PJ Monta is not there. He's a senior counsel. None appears on behalf of the petitioner on call. The R.K. Jain, the learned counsel, appearing on behalf of the respondent number 4, submits that it was duly intimated on 5/1/2023 that the petition that the respondent number 4 had expired. It seems that the petitioner have lost interest in the instant proceedings. And according, the instant petitions therefore stands dismissed for non-prosecution.
That I have informed that can be recorded.
From what? Who are you?
That file has been taken up.
Who are you? You're nobody. Taken from Rubul Ali. Rubul Ali is not here. Who are you? You have not signed wakalatnama. Same continue till the next thing. Huh?
It's the review, Lordship.
Oh, your review, that matter.
I kindly peruse order dated 9/1/2024.
Yes, what has happened, Mr. Gogoi? What is it? You have filed an edition affidavit. 19/6. Ah. Finance does not. Huh?
Open to page 105.
Ah.
The power to adopt or issue in the subordinate of. Right, the academy of. The higher authority commissioner has the power to make it a.
No. Here is the issue as to whether the commissioner, as to whether the district establishment rules will apply. Wherein it says that for junior assistant, you require graduation. Which look? Our Like receipt. So these are all these branches are at page 110 are branches under the DC. Because these are all DC branch. Nazarat branch, election branch, modern branch, development branch, this land acquisition branch, land Bakizai branch, census branch, land excise branch, land revenue branch. These are all under the deputy commissioner. Then, with reference to the, I have the honor to submit herewith the following branches functioning under the amalgamated demand of the office of the district commissioner. Reference to the above, I have the only. What is them? Now, where is that document they are referring to? They are referring to some document, no? 43. Then there is one direction, some letter issued by the person, no? Subject to reversion in manner. No, there is some letter they have referred to, issued by somebody. Huh? 875. This was given in 2021 by the Assistant Commissioner. There is no service rules for the subordinate officers under the Commissioner of Environment. The said circular stipulates the minimum qualification when AI as agents in affecting the adhered to. Further, in promoting grade 4 employees, there is no provision. Yes, so. This was given in 2020. 2020. And when was this amendment happened?
So this is the communication. Oh, is
The concern with junior assistant, na? Directorate establishment, nahi. It will be under the level.
ask the SSLC or equivalent examining.
Which you are reading? Because this was issued at a point of time when grade 4 matriculate HSLC was the year. Yeah. When all over where they are following this,
Mention about the amendment.
where?
As amended, why not?
10%.
Point of time, this was similar.
Hmm.
2015 now is the moment they joined the particular code.
No.
But
But
that
their condition is
this
that
office referendum has not been superseded.
circular of 1995. I think that the amendment, this is a qualification for
No, but Mr. Gokul, I did not understand what is the tenure of this letter, the last letter. Means I didn't get a, means what is this page 113? Says the recent year. Uh, uh. I have the honor to state that all in charge of subordinate officers, namely Deputy Commissioner of Taxes, Assistant Commissioner of Taxes, and Superintendent of Taxes of respective zones, are the appointing authorities themselves. Hence, recruitment process in earlier days were initiated by their level. Therefore, it is mentioned in first para of the said OM. Which OM? Yeah. Oh, yeah.
For promotions in the
Where is it mentioned there? Now, where does it say? He has quoted something. I don't think. I don't mean this. Follow that. Where? It's clarified that for the benefit of all heads of the offices under this commissionerate, that they themselves have to dispose of such representation, and the commissioner of taxes cannot pass any order in respect of such claims for promotion in office. Subsequent instruction regarding procedure in matter of promotion is clarificatory. The nature of simple guidelines. So you are saying that these are only simple guidelines.
But Lordship, that was sufficient.
But why the assistant commissioner has done that? The commissioner has no time. So you say that subsequently it is clarificatory. So you have mentioned, therefore, as there is no service rule, this aspect. As there is no service guideline, they should follow these, all these things. These are only clarificatory and simple guideline.
An admitted position that there is no service rule. And to that extent, Lordship, these are to be followed, Lordship, in terms of one judgment. I found out one judgment, Lordship. One paragraph, Lordship, will kindly bear with Lordship. This 1999, 8 SCC 99. I'm relying upon paragraph 8.
But I don't understand one thing. When you are having for everybody a degree, why you are not having for them? Yeah?
Para 8, Lordship.
State government has not made it to be mandatory held by the High Court, then it is difficult to go to the High Court. The impugned judgment. Yes, what do you mean to say?
Lordship, in absence of any rules, these executive instructions will
There's no quarrel with that. You don't require judgment for that. I think I know. I not be doing a lot of service matters.
just in support of that I am placing.
No, I understand, but one thing, what is happening is, when in every stream from 2015 onwards, for to get to the post of judicial assistant, you require a degree. And for the Commission of Taxes, you don't require. The Finance and Taxation Department, even if it is for the ministerial also, you require. If they don't have, then it has to be, what is wrong?
To amend it, Lordship, otherwise, any other circular, Lordship, went to this, Lordship, amending this provision, Lordship. Otherwise, Lordship, this is still
Now tell me, has any other person during this period been given any benefit?
just page 75. Probably.
Huh?
Page 75. That was in 2020, Lordship.
Page 75.
At the bottom portion,
Now this I've looked into.
at the bottom portion, Lordship will see, number 2, B and C. Those are the 2 persons, except this one.
Regards the minus of the it is to be mentioned that no department of is formed two of the incumbents
Subsequent,
educational qualification. Then
those 2 have
paragraph two, B and C, those were having qualifications of HS and those were promoted lordship. And
They were promoted to the post of LDA. Yes.
they were all grade four stuffs. Junior assistant.
Huh?
LDS slash junior assistant, lordship. Any of
You are judicial assistant,
junior assistant.
junior assistant. Now you want,
I was a grade four employee.
they want to be junior assistant.
The office memorandum, it's LDA law.
Writ petitions are pending.
Don't have that tool lordship. Have to notify it lordship. No, they themselves say it lordship. I need not place that lordship.
Huh?
Has to be notified lordship. In their affidavit lordship will kindly see what they have in the earlier affidavit lordship. Page 90. Paragraph 4.
Yes.
I am reading the whole paragraph lordship.
Read the whole thing.
That with regard to the statements made in paragraph A of the review petition, the deponent begs to state that the then Commissioner of Taxes issued a circular file number so and so dated 6/4/1999 in the form of office memorandum wherein it was impressed that there is no service rules for the establishment of subordinate offices under the Commissioner. The Assam Ministerial District Establishment Service Rule 1967 is generally to be followed. According to the AMDE rules by government notification number so and so dated 17/3/94, 10% of the vacancies of LD assistant in any year is to be filled up by selection on the basis of seniority cum merit from the grade 4 staff of establishment who have passed HSLC or equivalent examination and have rendered continuous 7 years of service. Accordingly, the then Commissioner of Taxes advised the head of its subordinate offices to consider the promotion of the grade 4 employees who have passed HSLC examination. Next para. The above office memorandum issued on 6/4/1999 has not been superseded by any subsequent order or amended or cancelled till date. This is the line lordship which I am relying on. But the AMD rules has been amended from time to time, and in the year 2015, the minimum qualification for grade 4 employee is made a degree from recognized university to promote to grade 3. In view of the subsequent amendment in the AMDE rules, two schools of interpretation emerged. From one angle, it appears that since AMD rules does not govern the establishment of the subordinate offices of the Commissionerate of Taxes Assam, changes amendment in the said order leave no impact on the minimum qualification in considering the promotion of grade 4 employed to grade 3, and therefore those have minimum qualification of HSLC pass are eligible to get promotion. On the other hand, careful examination of the office memorandum dated 6/4/1999, it appears that the mainstay of the said memorandum is rest on the AMD rules.
Mr. Gogoi, you find on judgment of the effect that if there is no service rules And at whole existing issues were given out there at that point of time, 99, when the qualification was HSLC. Subsequently, if most of the departments or in terms with debt service rule holds a person of similar category to have 2050 the degree qualification, then without any amendment also, there's no requirement. These are all instructions. These are only instructions out there.
Lordship,
So
that
nothing.
may be lordship, but that was the procedure.
First of all, who are you? You are review petitioner, but you don't stand any chance. You have gone. You are fighting for Mr. Sahu. You are junior.
So, lordship,
You want to later on again come, because the problem which will arise is if I give one here anything, I review it, Mr. Sahu's client gets it, then tomorrow Mr. Sharma's clients get it. This will have a serious consequences, and this will amount to a discrimination. There is no doubt I'm going to dismiss it. I'm only wanting what is the good grounds. And the ground I have also thought about it. But I will do it in your presence, because I would not like to list the matter again on three. 1st of August 2024 at the top of the list. No, I know what is your submission.
second or third.
Certificate of incorporation.
Third minute, on third minute.
What
Because
third?
First I will be not there. Yeah,
Third you come.
third I.
You only come. I am going to dispose of it first, because third is a Saturday, courts are closed.
Sorry, then we don't. So, 29 I do not have any problem.
29th I have no time. I won't be here. I am not here.
On 31st and 1st, I will not be here because that is the problem.
Hello. Okay, on 6th of August. This I'm going to dispose of, and whatever may be,
My submission
I am going to dismiss it. Whatever may be, you go by the General Clauses Act, you go by the of incorporation, legislation by incorporation, everything. The law has to be applied properly. And anything you want to go to the division bench, let the division. But my conscience of this court does not permit anything to be done to that.
on that day, I may be allowed to argue on that point.
To argue whatever may be, that is your lookout. But if the matter starts at 10:30, by 11 the judgment will be pronounced, done and dusted. 10 minutes for you, nothing more.